Your Lordship, I express my gratitude for upgradation of my matter in item number 60, my lord.
Item?
Item number 60 in supplementary list.
Huh.
My lord, unless this matter is taken off in the first step, your blessing should be infructuous, my lord.
What is that?
Your blessings for inclusion of my matter, unless this
What
matter.
blessing and what blessing do you have I
You know,
given you?
yesterday I had mentioned this matter, my lord. This matter was not in the list. Your lordship was very kind
There's
to.
no such thing as blessing in this court.
My lord, I mean, this is aside the law. This, my lord, this is
No,
simply.
you've made a mention, we got it listed. So we'll
Sure.
take up the matter when the time comes.
My lord, unless you take up at two at least.
We'll see.
My lord,
Yes.
grateful, my lord.
My lord, this matter may be listed for motion on Monday, my lord.
Why? Why?
This matter relates to the declaration of result of 10th semester LLB examination, my lord.
Ah,
So the result has been withheld, my lord. And the next
when
exam,
was it declared?
it was declared, my lord, it was withheld since 2023, my lord. It has not been declared.
Oh,
And the,
then what,
my lord,
what were you
and this
doing
is the
taking
last
so long?
to appear as a, my lord, for her back paper. This is her last chance. Unless and until this result is declared, whether she passed or not, she will not be able to appear in the next examination.
Which university?
My lord, Guwahati University.
Have you given notice?
Yes, my lord, we have certainly.
Okay.
My please, Lordship, I beg to mention for listing in motion, my lord. This matter may be listed on Monday because my lord, this case related to TF appointment, my lord. This is about to be
Appointment of?
about to TF appointment, my lord, in the
Okay, 3F.
on 19, my lord, Monday.
Now, what is the urgency there?
Consideration is that my lord, where on 22nd, my lord, the term will be over, but they are not selected, my lord. Since they are entitled, my lord, they have the legitimate right. Already, my lord, lordship has passed an order, some observation has been made. We make the payer for similar relief, my lord, in the light of that order, my lord.
May I please, your lordship. Your lordship, I beg to mention item number 35, your lordship.
30?
35, your lordship. With the consent of the other side, your lordship, the matter may be possible for the day, your lordship.
35.
I am for the respondent, your lordship. Private respondent.
Yeah, Mr.
I.H. Lester.
Anybody for the petitioner?
We
You have informed the petitioner?
You have informed, your lordship. Consent has been taken, your lordship. from the petitioner's
You have
side.
taken consent?
Yes, your lordship.
Okay, on request made by I.S. Laskar, on the council for respond number 4.
Yes, your lordship.
List the matter after 1 week.
On 2nd June, your lordship.
On the second.
Another clarification with regard to item number 30, your lordship. In that matter, your lordship will file one additional affidavit that may be called for, your lordship.
Item 30, you're done?
We are the for the petitioner, your lordship.
Okay.
May I please, your lordship? My lord, I beg to mention item number 20 with the consent of the other.
Item?
27. your lord.
Yes, please.
My lord, the respondent has filed affidavit in opposition day before yesterday, lordship. We filed affidavit in reply, your lordship. So we may be granted 3 weeks time, lordship.
You are Mr.
P. Colita.
Your lordship, I appear for respondents. Your lordship, 2 weeks time may be granted because they're enjoying a stay. The matter relates to de-affiliation of the school.
Mr. P. Kalita, of the council. Raise for 2 weeks time to file and file reply to the counter affidavit filed by the respondents.
Rest 1, 2, 3, 4.
2, 3.
Lordship, there is an interim order that may be copied.
List of 2 weeks, interim order pass relief to continue to the.
Some date
Okay.
may be fixed, your lordship, because they're enjoying a stay order. It's regarding de-affiliation.
Give a date after 2 weeks.
First week of June,
4th.
4th. Highly obliged, your lordship.
My lord, I beg to mention one contempt petition in the order column. The last date was of March, 10th of March. Further instruction was sought, but that is not yet, my lord, listed. For urgency is there, so any date next week,
Yeah, 28.
28. Obliged.
May I please, your lordship?
That's why I'm praying for listing of a matter in the admission column, lordship, in the first week of June, lordship. This matter has not been listed since November, lordship, last November.
4th.
4th of
May, lordship. Similar pair, my lord. Listed on last listed 4th February, my lord. Admission matter, my lord. Any date.
2nd June.
Develop.
Maybe, lordship, I beg to mention for listing, lordship. Last posting on 24/3, Lordship. Content matter. Lordship.
Okay. Second,
Lordship, I'm praying for listing one petition for admission, Your Lordship. It was last listed on 5/8/2024.
2000,
Next weekend,
second June.
second June. Apply.
Lordship. Item number 27, I have an interim order, Lordship.
Item
27, Lordship. I have already mentioned, Lordship. Let me be continued.
Item 27. I told you, interim order process.
May I please your lordship? Lordship, I beg to mention for listing of one repetition lordship. The metro was last listed on February lordship, 6th of February lordship. Metro will be listed on 23rd of this month lordship. 23rd.
28. 28 May.
May I please your Lordship? Lordship, I beg to mention item number 12, Lordship.
Item,
Item 12, Lordship.
okay.
We would like to withdraw, Lordship, take a liberty to file fresh.
Your good name?
Mr. P.K. Das, Lordship.
Mr. P.K. Das, council. Praise for withdrawal of this petition. Liberty to file afresh. Secretary who appears, MS and M. Sharma, and the standing council appears to the secretary. The petition is dismissed on withdrawal with liberty as well.
My lord, I paid for listing of a writ petition in admission column that was last listed on 18/12. Thereafter not listed.
Okay, 28.
I beg to make a mention for an admission item, Your Lord. The matter pertains to gratuity and post-tail benefits, which has not been released as of now. Subject to your Lordship. Any date subject to your Lordship.
30.
30, my lord. Good.
May I please your lordship? Lordship, I beg to mention item number 29 for admission. The petitioner seeks to file a consolidated affidavit in response to the affidavit filed by the finance department. So if time may be given after 2 weeks, lordship.
Okay, MS.
Yes, I have taken the consent. from
Your
the-
good name.
Oh, P. Kundu.
Hmm?
P. Kundu.
You are appearing on behalf of
R. Sensua.
on request made on behalf of Mr. R. Simpson and council for the petition. How much time?
After 2 weeks, lordship.
2 weeks time is allowed. When you apply to the counter affidavit filed by the finance department. List up to 2 weeks. Yeah.
My lord, may I please your lordship, my lord, I beg to mention for listing of a motion item, my lord, on Monday, my lord, what has happened, my lord, our great pay has been interfered with without hearing us. So some urgency is there, it has not been effected yet. Probably by Monday or Tuesday, they are going to give an effect. Oblige, my lord. My lord, I also beg to pray for listing of 2 admission items, but not listed long, from long pending, my lord, on next week, any date, my lord.
30.
30, my lord. Highly obliged.
May I please your lordship? Okay, I beg to mention for listing lordship for admissions, matter relating to professionalization of the petitioner service sources. Kindly
2nd June.
Item 1, withdrawal.
May I please your Lordship?
Yes,
Prayer for withdrawal, Lordship. Item number 1 is 2.
you want to withdraw?
Yes, Lordship, matter has already become in process, Lordship.
Okay, Mr. D. Boyan, then counsel for the petitioner submits that he has instructions to withdraw this petition. Government advocate,
I'm limited.
Mr. P.K. Boral and its standing counsel appears for the elementary. And MSS Cornwall and the government advocate appears for the state respondents. This petition is dismissed on withdrawal.
My lord, may I have a similar prayer in respect of item number 26, Lordship? This matter has also become in process, Lordship.
Mr. D. Boyan, and counsel for the petitioner submits that the matter has become in process. Mr. P.K. Boral and his standing counsel appears for the elementary petition. This petition is accordingly disposed of as instructions.
Oblige, Your Lord.
Item 3, motion.
How about item 2? Item 2. Well, let's call him back because I passed the order only 9. Item 1.
Item 3.
And the direction is to release the pension. Your lordship will find it at page 14, para 8. Page 14, para 8.
It not been paid till now. But Mr. B. Bhatwa, very confident. Issue notice. Petitioner to take steps for service of notice on the respondents 1 and 2 by registered proceeding within 1 week. List of performance.
Item 4.
Well, this honorable court order is at page 9 and Relicard lordship is at page 12, para 6. Lordship.
Yes.
Para 6, lordship. That has not been complied with. After that, lordship, they have made some communication between the authorities.
Okay, heard Mr. M. Khan, level comes. Issue notice. Petitioner takes steps for service of notice. Is the accountant general a necessary party in the contempt?
My lord. Sorry, lord.
Is it necessary to issue notice on the accountant general?
Yes, lordship, all are necessary parties. That
Yes.
all are necessary parties, lordship.
Petitioner to take steps for service of notice on the respondents, on all the respondents. By registered proceeding within 1 week, list of the formats.
Public.
Item 5.
Lordship, this is regarding the release of first basic salary of the petitioner, your lordship. Petitioner was accommodated as state or your lordship, page 16, your lordship. Lordship has disposed of another similar rate petition directing that petitioner to file a representation, your lordship. This is.
Yeah, Bora, any instructions?
We have not received any instruction.
In that respect, your lordship can dispose of the rate petition, your lordship. Giving the petitioner to submit representation. Thank you.
Did you make a representation earlier?
Yes, your lordship. Page 24.
This is before the secretary. Page?
Page 24, your lordship. Along with another similar candidate, your lordship.
It has to be before the director.
Director.
My lord. Okay. Heard Mr. K. Mera, let me confirm the petition. Also heard Mr. P. K. Boran and the standing council elementary education for the respondents 1, 2,
4, 5, and 6.
4, 5, and 6, and MS RM Barwal and the standing council finance for the respondent number 3. Stop. Who is the order? The petitioner was accommodated
Page 16.
as a tutor in LP oblique UP school on purely temporary basis in the fixed wages at the rate of rupees 10,800 per month under the Deputy Inspector of Schools oblique District Elementary Education Officer consent of Hailakandi District with effect from 1/11 to 2020. Stop. 2020 by an order dated 23rd September 2022 issued by the Director Elementary Education, Assam. Stop. by the said order dated 23rd September 2022. The petitioner was posted at 539
Yes, sir.
number
Bonduk Mara.
Batuk Mara LP Street. Stop. It is the case of the petitioner that from the date of accommodation as a tutor, he has not been paid the fixed wages at the rate of rupees 10,800 till date. Stop. Being aggrieved, the petitioner made a representation before the Secretary Education Department within Bracket Elementary on you made a representation with another person. With another person.
Another person.
Okay, then being aggrieved, the petitioner, along with another similarly situated person, made a representation before the Secretary Education Department within Bracket Elementary on 5/2/2025. However, till date, the said representation is yet to be considered. Stop. Para. After hearing the learner counsel of the parties, this petition is disposed, directing the petitioner to file a fresh representation, annexing all relevant documents before the Director of Elementary Education, Assam, within a period of 1 month, 1 week from today. Stop. Thereafter, the Director of Elementary Education, Assam, on receipt of the representation made by the petitioner, shall consider the said representation and dispose of the same in accordance with law within a period of 1 month from the date of receipt of the representation to the above observations and directions. With petitions responsible.
And 6.
In this case, lordships, that I have been directed to file an affidavit. In this case, we have received instruction, and in this case, our learner senior technical, he will address this. So anyway, lordship may kindly fix it on Wednesday. Next lordship, we will file the affidavit in the meantime.
Witness there.
Yes, sir.
My lord, may I pray, my lord?
And before my learners can start lordship, here challenge the provisional garrison list. Now he filed this case challenging the provisional garrison list prepared by the inspector school Lakhimpur lordship, page 132. The lordship can turn to rule 18, lordship page 43 of this new book lordship. There is a provision for filing appeal within a period of 7 days. When the draft provision, the draft lordships garrison list was published lordships, but without filing any
Petition list
on page 123 lordship. 132. It is a provisional garrison list of AHM, all the provincial high school dated 23/2025 lordships. And now turn to rule lordships 2018 rules, page 43.
2018
rules lordship,
page
page 43. Rule 25 garrison list lordship, sub rule 3.
page 43.
Yes, sir.
Yes.
Sub rule 3 lordship. The draft garrison list shall be published by the appointing authority for every district in the beginning of each calendar year, inviting objection from each incumbent by endorsing a copy of the same. The incumbent concerned shall be allowed to submit objection, if any, within a stipulated period, which shall not be less than 7 days. Thereafter, the final garrison list will be prepared. Lordship. Here, lordship, it is in the provisional list was published. He has not filed any objection before the issuing authority. Lordship. And final garrison yet to be published. Lordship. So we like to file an affidavit in this case regarding other things and let it come on Wednesday. Lordship.
Yeah.
And nothing will happen. Lordship. Only the day before yesterday, code of conduct was lordship withdrawn. Nothing will happen. Lordship. Till Wednesday.
My lord, may I submit, my lord? My lord, with all respect to my respected senior friend's anxiety and submission which he has made, because this is my case, my lord, and I have not been bringing into the notice of your lordship that what prayer we are making, my lord. My lord, may kindly turn to page 29. Yes.
My lord, if my lord may be pleased to peruse the prayers, my lord, which we have made, we are not praying for a sanctuary for setting aside the gradation list. My lord, whatever the gradation list they have prepared, we do not have any objection. That we only want, my lord, that our name, by treating us as a graduate teachers from the year 2001, we should be placed in the appropriate place. That is only our limited prayer. Now, my lord, in the meantime, what has happened? They have this provisional gradation list. My instruction is that, my lord, during this course, my lord, when we filed the petition and came up before my lord, they have already, this finalization has been done, though we have put some objection regarding the, my lord, that our name should be included, that we are not saying that it should be set aside or modified. Now, my lord, the problem is that, my lord, on the one hand, as there is a schedule had been fixed, if my lord may be pleased to peruse page 69, my lord. No, my lord, I'm sorry, my lord, it is at page 129. 6th of March, 2025, my lord. My lord, this is a restructured, my lord, schedule for the purpose of how the selection process shall going and it should culminate. If my lord may be pleased to find that the preparation and the finalization of the cadre-wise gradation list containing the name of all members of the service as per Rule 25, my lord, date 6/3/25 to 20/03/2025. Only 15 days time had been provided here in my lord. Now, and thereafter, my lord, it will proceed in accordance with this schedule, and it will have to culminate on 7/4/2025, because only due to the code of conduct, my lord, this process has been stuck at this moment, my lord, on 7/4/2025. Now, my lord, only thing is that as our name has not been included in the gradation list, my lord, we will not be summoned or called for to appearing in the interview. Under a similar circumstances, my lord, in the earlier round of litigation, my lord, when which came up before my lordships, my lordship protected those petitioner by an interim order that we were allowed to participate in the, my lord, selection process, but our result has been directed to be, my lord, not to be declared without the leave of my lordships, my lord. Exactly, my lord, similar, my lord, interim prayer I am asking for. In the meantime, my lord, my learned friend can file an affidavit, my lord, and to satisfy that we are not entitled, my lord. No prejudice will be caused, my lord.
This
to the
is no
state
interim
of-
order should be lordship, let me file the affidavit, lordship will take it up that day for final disposal, lordship.
But are you taking steps?
No, lordship, and this morning I have talked with my director, lordship. The
Then my
final
lord-
gradation did not yet prepared for suppose Lakshmipur district is concerned, lordship.
Final
Yes,
gradation
yes,
list?
yes, lordship. And there's a provision for if they have the grievance that their name is not included, they could have filed an application or appeal before the inspector school,
My
lordship.
lord, we are not
They have not-
challenging the same, my
Then
lord.
can I,
There's
can
no
I,
question of challenging, they could have filed an appeal
can
before.
can I make a record, can you record your statement saying
Yes.
that the final gradation list of Lakhimpur
Yes, lordship, I can take the 5 minutes. I have a call with the, let me talk with the inspector school. I'll,
has not been finalized
yes,
My lord,
after 5 minutes?
yes.
my lord. Obliged.
Oh, next case discussion. Item 2. No, I think it's not official. Item 2.
Item 2 also you're withdrawing?
Yes, my lord.
Mr. D. Boyan, the
Yeah,
member
that's
also submits that he has instructions to withdraw the present. Secretary, Mr. S.
Yes, yes.
Still on standing council appears for the secretary division. Stop. The petition is dismissed and withdrawn.
Obliged, your lordship. May I please as your lordship? My lord, here we are agreed by way of, my lord, conferment of the charge of the office of the principal of, my lord, the Nagaon, my lord, Government Girls Higher Secondary School. My lord, may be pleased to find the impugn order is at page 17.
Yes.
My lord, by way of this order, this charge had been conferred, my lord, to one, my lord, the private respondent number 4, my lord. Though she is the junior most teacher of the said school, my lord can verify the seniority, my lord, is at page 16, annexure 1, my lord. My My lord, serial number 5 is the private respondent who had been conferred with the charge. If my lord may be pleased to find, her date of receiving the graduate scale of pay starts at 22/11/1999, my lord.
Column,
Column number, my lord, from 1, 2, 3, 4, 5 column from left side, my lord. Column number 5, it is the date of receiving graduate scale of pay.
I'm very sorry to
My
say,
lord.
my lord, my annexure is very illegible, lost. It is,
Hmm.
we cannot lost.
that much, no.
Yes, should have submitted his type copy along with this. Yeah.
Good dear.
Good dear.
আপনি মোৰ কপিটো লৈ লওক।
No, no, no.
And you are the,
My lord, we are the, my lord, 1, 2, 3, and 4, my lord. We have challenged this that the seniority criteria, 3 petitioners are before me, lord, and the Hemakanti Das, the my lord, the serial top of this in the list, my lord, we are. My lord, my prayer today is very limited, my lord, because we have made a representation long back, my lord. My lord may be pleased to find that representation is at page, my lord, 18, the translated one, and which had also been acknowledged by the director on 1st of February 2025. That, my lord, we have agitated our grievance that the seniority had been violated while conferring the charge, my lord. At page 18, my lord, may kindly have a look, my lord. So, my lord, this representation can, the authority can take a call and can dispose of by of an speaking order, my lord. That's,
After hearing all the parties, including the respondent four.
yes, yes. Why she should not?
but Mr. A.R. Buyan, was a counsel. Petitions also heard. Mr. S. M. Chisti, standing counsel. Secondary Education Department for the respondents, 1 point. But how many petitioners?
My lord, only 3, my lord. They are the senior to the
The-
private respondent.
The 3 with petitioners
One.
before this court claims that they have been working as teacher
One.
in the Naugong Government School, a government girls higher secondary school since the year 1993 from 1993
And 1995.
and 1995 stuff. The respondent number 4 joined with the same school in the year 1990.
My lord, 22/11/1999, my lord.
Date of joining as graduate teacher, you know,
Graduate teacher, my lord, but receiving the graduate scale of pay from 1999, my lord. 22/11/1999.
joined on 22/11
Fine.
1990. Stop. Stop. The grievance of the petitioners before this court is that on the eve of retirement of the incompetent principal of the said Naugong Government Girls Higher Secondary School on 31/2025, comma, the respondent number 2 oblique Director of Secondary Education Assam issued an order on 31/2025 allowing the respondent number 4 to act as principal in charge of Naugong Government Girls Higher Secondary School, comma, District Naugong, along with financial power to draw and disperse salary, etc. of the staff of the school in addition to her normal duties as postgraduate teacher. Stop. The further case of the case is that in the category-wise
Mark.
seniority list of graduate teachers and postgraduate teachers issued by the principal of the Naogong Government Girls Higher Secondary School. The names of the petitioners number 1, 2, and 3 appears at serial number 1, 2, and 3 in the set seniority list. And the respondent number 4 and the name of the respondent number 4 appears at serial number 5. And therefore, comma, the senior most graduate teacher should have been allowed to act as principal in charge of the said Naogong Government Girls Higher Secondary School. Stop. Being aggrieved, comma, the petitioners made a joint representation before the Director of Secondary Education, Assam, on 1/2/2025, which is yet to be disposed of till date. Para. Learned Counsel for the petitioner submits that the petitioner should be satisfied if a direction is issued to the Director of Secondary Education,
Respondent number 2, Milo.
oblique respondent number 2, to consider and dispose of the representation within a specific period of time. With a representation dated 1/2/2025 within a specific period of time. Stop. Para. After hearing the learned counsel for the parties, the split petition is disposed. Directing the respondent number 2 to consider the representation made by, to consider the joint representations made by the petitioners on 1/2/2025 and dispose of the same in accordance with. Stop. While considering the representation, comma, the petitioners 1, 2, and 3, along with the respondent number 4, shall be given an opportunity of hearing. Stop. Thereafter, the said representation shall be disposed of within a period of 1 month from the date of this of a copy of the order.
And pass a reason order, Mr.
Certified copy along with the copy of the repetition lawsuit, because it is disposed of the motion case.
With a period of 1 month by passing a reason and speaking on. Huh?
They would submit that copy of the repetition also along with the certified copy.
Then the petitioners are also permitted to furnish a certified copy of this court order along with a copy of this petition. Before the respondent. Within 1 week.
Yes, yes, Milo, within 1 week we'll do. Highly obliged.
My lord, there were two rounds of litigation earlier. Eventually, when the writ appeal of the respondent number 4 was dismissed, my lord, the authority considered the matter. Now, regarding initially, my lord, the plea of the authority was my BH certificate is not valid. That has been cleared by this honorable court. So now, my lord, the alleged plea is he got equal marks, therefore they have resorted to lottery.
What then?
Lottery.
Lottery.
Yes.
For selecting a principal of a higher secondary school, my lord, in the purported selection, both the petitioner and respondent number 4 each secured 15 marks. Then they resorted to lottery.
Oh, okay.
How can that be done, my lord? It has to be set aside and matters should be remanded back. Kindly see, my lord, actually this impugn order was passed on. Please come to that impugn order, my lord.
Page
70, my lord. It's a long order. Then if your lordship would kindly come to page number 72. Accordingly, a hearing was conducted by the State Selection Board on 21/11/24 And as per the hearing report of the State Selection Board, it is found that Biren Soikia, that is the petitioner, and Sri Biren Bora, the respondent number 4, were awarded same marks, 15 in the selection process. And Sri Biren Bora has already been appointed as a regular principal of Kheras Khat Senior Higher Secondary District, Lakhimpur. Fixation of pay was made by etc. etc. Then this is the chart is given below. Hence, there was no alternative choice left for the State Selection Board regarding selection of regular principal, so and so. After threadbare discussion and mutual, this is wrong, Miller. There's no mutual. In fact, both the candidates on it 12, 21, 11, 24, both objected. That don't adopt this procedure. That we have stated, Miller. And so therefore, by lottery, Miller, it was decided. Now, Miller, kindly see this. In this very committee, secretary was also a member. Now there is a rule of the state, Miller, which we have annexed. Statutory rule at page 77. Now this is, Miller, Assam Secondary Education Government School Service Amended Rules 2023. Now if your lordship would kindly come to page 78. In the middle, there is a proviso. Provided that in case 2 or more candidates obtain equal marks in aggregate, the candidates getting comparatively higher marks in B.Ed education shall be preferred. And if such situation again prevails, then seniority of age shall be preferred. So it's not that, my lord, the state government is not aware of these provisions. My lord, how can by a draw of lot somebody is failing to be decided?
Yes. We have to take instruction.
No, what's this?
Yes, we have to take it.
Okay, 1 week.
Indian order is
One
of
week, 1 week.
2024. Yes.
1 week time.
Ah.
But see, this when you have got your own rules,
I'll definitely.
follow your rules. Otherwise, why did you make this rule?
Or let the matter remain in motion, let my learned.
No, I'm not issuing notice.
Yes.
We keep it in the motions.
Yes.
Next day we
Yes.
dispose. Third KN Chowdhury and senior counsel, presented by Mr. Learned counsel. Mr. Assembly Trustee and Standing Counsel. Secondary Education Shelter Inspectors. Give a date.
Next
week,
or next Friday?
Friday, bro.
Next Friday.
23.
23rd.
Yes. Deep look.
Item 9. Huh?
May I please, Lords? Here, before Lords, the first wife of Nizamuddin, who was subject teacher of my Lord Singimari Muhammad Ali Higher Secondary School, my Lord, who expired on 17/9/2023, my Lord. Thereafter, petitioner being the first wife approached the authority for family pension, my Lord, as well as second wife also approached, my Lord. But my Lord, the authority allowed us a pension, my Lord, family pension in the name of second wife, my Lord. Then she filed a complaint before the treasury officer, my Lord. Then treasury officer with all necessary documents. Then treasury officer sent a letter to the director of pension to take appropriate steps in this regard. Director sent a letter to the IS inspector of schools, Nagaon, to inquire into the matter and submitted detailed report. Thereafter, the inspector of schools heard all the parties and submitted a report, my Lord.
Where's the report?
Report, my Lord, page, my Lord, 25. Page 25. There is the report sent to the director of, my Lord, pension by inspector of schools. And the matter is pending before the director of pension, my Lord, till date, my Lord. So my limited period before Lordship, your Lordship may dispose of the matter directing the director of pension to take necessary steps as per report submitted by the.
Yes, Deori. You take instructions and come back.
Yes, sir.
Heard, Mr.
Biram.
Then the council. Mr. B. Deori and government. Appearing on behalf of the director of pension shall take instructions. Particularly with reference to the communication dated 31/2025, written by the inspector of schools NDC Nago and addressed to the director of pension Assam. List down.
After a week, after 2 weeks, let a copy be punished. Let a copy.
Instruction 23rd.
How much time do you require?
Lordship. May it be
On 30 May.
yes. Because
Item 10.
hello. Make please, your lordship. My lord, this is the compassionate appointment lordship. It's covered by lordship judgment lordship. It's covered by lordship judgment lordship, order lordship and other analogous matter lordship. Page 54 is the order. DLC is approved by case, but SLC lordship, then I approach this honorable court lordship, page 54.
1 minute. You approached this court, your case was rejected.
Rejected.
And so you approached this court
Page 54.
52.
54 is the operative portion of the order lordship. Then the lordship, in the meantime, that notification came into force lordship. And by virtue of that notification lordship, my case was rejected. So I pray lordship, the entire matter may be remanded with
Who rejected your case?
lordship by the secretary lordship.
Where?
Uh,
By the SLC?
Not a mention as but subsequent last paragraph lordship, page 67.
1 minute.
Page 67 lordship. Order issued by the secretary lordship. After careful consideration of the above findings and seeking in introduction. Consideration, the embargo laid down by the owner so and so and office memorandum 18/9/24, as well as taking into consideration cases by so and so, SLC is considered rejected the proposal of compassionate development. So I pray lordship as per paragraph 9 lordship, 9(1) lordship, my case
No,
is
what is page 69?
lordship. 69 is the similar analogous order lordship in other cases.
Oh, no, this is not you.
Not mine. My case is page 54 lordship, earlier rejected by the SLC, page 54.
And your rejection by the SLC?
SLC lastly rejection lordship, page 67 it is mentioned lordship. Rejection order, the decision lordship of the secretary.
Date two. Date two.
30/11/24. So lordship judgment, lordship paragraph 9, first paragraph 1 is covered lordship by that lordship. Lordship in the judgment lordship paragraph 9, referred judgment of WPC 342 of 25, paragraph 9(1) lordship. It was specifically mentioned the which was rejected, it was set aside lordship. And referred the matter to the government. I pray lordship that my case may be reconsidered lordship, since the other analogous matter already disposed by this honorable court lordship.
Yes, duly.
Lordship, here, as the background on which it was decided, at page 67.
Yes.
Okay. That a lack of immediacy, the SLC is constrained to reject the proposal on compassionate of Suman Raj Firoz.
Yes. In terms of the office memorandum 10/9/24 lordship. But in the judgment of lordship, analogous judgment of that this honorable court and other coordinated bench also lordship, similar.
1 minute.
I pray lordship this matter may be referred to the.
Yes, duly.
The ground which that has been mentioned is that taking into consideration embargo laid down by Honorable Supreme Court and OM dated in
That OM lordship is already under challenge lordship. And by virtue of that lordship, all other matters are lordship remanded back to the government lordship. Paragraph 9 lordship.
as well as taking into consideration that the case is hereby lack of immediacy, the SLC is constrained to reject the proposal on compassion. So that lack of immediacy part he has to overcome, he has to show that is one. Otherwise,
No,
There-
this order was passed on 30/11.
yes, that is one part. That
Lordship.
is one part.
2024.
That is for that purpose.
After-
Kindly please.
1 minute.
For that purpose, how they conducted the said SLC after their own office memorandum was issued.
That's the issue.
In that all those
How-
some particular cases, how they could. So in that aspect, I have to take the instruction. I have to take their feedback.
Yes, the issue is this. Now the government has issued that memorandum.
Yes,
Now, when the petitioner's case was considered,
yes,
the SSC acted against that memorandum.
yes.
All right,
Referring to that memorandum.
acted against that.
Yes.
Because at that point of time, they was said no SLC, no
No,
DLC.
not yes.
But by the time this court passed the order in
Yes.
3-5, I think,
342 of 25.
342.
Actually, this in respect, this SLC do not sustain by their OM itself.
Yes.
So just let me, why they did that.
Tendency, lordship, pending this, keeping pending lordship, other matters are already on process,
On
lordship.
request made by
It is very clearly
the-
mentioned.
Mr. B, the real and government itself takes instruction.
21.
21
Lordship,
next week.
yes, that 30th.
It's too far off.
Lordship, it may be
Let me, this 16. So maybe on 28. Only on 28.
11.
May I please, Your Lordship? My lord, petitioner is a head teacher, my lord. She retired from service on 30/12/2024, my lord. And she is governed by CPF, new pension rule, my lord. After retirement, my lord, now she is informed that the government subscription will not be given to her because of non-issuance of PRAN kit, my lord.
What?
Non-issuance of PRAN kit. PRAN kit means permanent retirement account number. This was not issued, so government subscription will not be paid to her. My lord, at this stage, my lord, notice may be issued, my lord. Since whether no written order has been issued, my lord. Just is or a lead.
Heard Mr. A. Mr. Chaudhary, HMR Chaudhary, London Council. Issue notice. MS. STTL and Standing Council Elementary Education Affairs for respondents, 1,
1, 3, 4, 4 and 5 maybe.
4, and 5.
3 to only.
1, 3, 4, and 5.
4 and 5 maybe.
Mr. B. Deodil and Government.
We are not there.
You're okay. MS RM Barwal and Standing Council, Finance Department. Appears for the respondents, 2 and 6. 2 and 6. Correct. Stop. Notice on respondents are complete. However, extra for this respondents are in the panel. List of the votes. Public. 13.
May I please, Your Lordship? My lord, herein we are challenging a, my lord, resolution that has been taken by the DSC, my lord, district level issue of Johat, my lord, as regarding provincialization of the petitioner, my lord. Here, the fact of the case is that my lord will find on page 31, my lord. Page 31. Page 31, that is the pro forma, my lord, submitted by the headmaster for provincialization of services of the, my lord, petitioner and other, my lord, eligible teachers. Lordship will file on serial number 1, my lord, Kuso Soikia. That is respondent number 6, he is a teacher of Assamese, my lord. On the right column, Lordship will file. Thereafter, my lord, Bhupen Kuli petitioner, my lord. On the right column, he is a teacher of social studies, my lord.
Who's the petitioner?
Petitioner Bhupen Kuli, serial number 2, my lord.
Okay.
He is a teacher of social study. And thereafter, my lord, on serial number 4, Amitabh Sarkar. Amitabh Sarkar, he is a teacher of Hindi, my lord.
Who's this?
Hindi respondent number 7, my lord.
Okay.
Here, my lord, that Assamese and English, my lord, two language teachers has been provincialized, my lord, ousting the petitioner. My lord, being a social study teacher, my lord is very much awarded as part of mandate of section 3111, my lord. It is mandatory to appoint one, my lord, social study teacher. Thereafter, my lord, being my lord, the petition, this is the, my lord, second round of litigation, my lord. Earliest, my lord, he has, my lord, approached before this court, honorable court, my lord. With petition was. My lord will find, my lord, interim order were passed, my lord. Thereafter, my lord, that the both on the my lord, consent of both the parties, they have been, my lord, prefer an appeal before the my lord, Secretary School Education. That my lord will find page 50, my lord. That is the order passed in the appeal, my lord.
Page,
Page 50, my lord, 50. My lord, on the table, my lord. Name of the schools, my lord, Puso Suikia, my lord, after perusal of the records, my lord, submitted by the, my lord, that, my lord, DEO, DSC, this order was passed, my lord, after, my lord, scrutiny of all the records. My lord will find on Puso Suikia name of teacher, he's a Assamese, my lord. Assamese, second, my lord, that is maths and science, that is, my lord, and three, Amitabh Sogar Hindi. These, my lord, findings are resembles with this, my lord, performance sent by the headmaster. My lord,
where's your name here?
my lord, my name has not been recommended.
Okay.
My lord, my lord, may I read this, my lord? In DE Assam had placed the proposal before the SLSC as well as the Joint Scrutiny Committee. Joint Committee constituted a committee under the chairmanship of so and so chairman of examine the proposal for provincial. After due verification of the records of the school and DICE, the verification report of the school and teachers submitted by the SSA Assam, the above mentioned teachers were recommended for provincialization of service as a tutor. Thereafter, DE Assam and DE Assam had submitted the proposal for provincialization of services of the above mentioned three teachers against the so and so school on the gov for creation of post, and after receiving the post creation of the Director Bilimi Division Assam has issued notification for provincialization on so and so. So, however, the name of the petitioner, Shri Bhupen Puli, was not recommended by the SLSC for provincialization of services, as name was not recommended by the DST. Jorhat being agreed, the petitioner filed and petition my lord so and so number in compliance of the Honorable High Court's order. The petitioner Shri Bhupen Puli was heard and so and so. Thereafter, my lord, the
After
decision.
this, what happened?
They, my lord, kindly see the decision.
Just I've seen.
In my lord, that petitioner being, in spite of being the social science teacher, he has been appointed.
You asked to review.
Yes, my lord, he has to be reviewed. My lord, thereafter, my lord, instead of my lord recommending the name of the petitioner, my lord, they are resolving, my lord, they are, that my lord will find on page 54. 54, my lord, what they are, my lord, trying, they are projecting this, my lord, Assamese teacher, that the headmaster Kusoshiki as a social teacher, my lord. This is language teacher, my lord, Assamese, which is very much apparent on the record. My lord, in the 2000, if the headmaster is neither of science nor of language out of two subjects, then the appointee as headmaster would be considered to teach lessons of social studies and any other subject apart from science or language. The headmaster of so and so school, Puso Soika, has been reaffirmed to teach lessons of social studies and any other subject apart from science and language in today's meeting. So it's absolutely arbitrary. It is a irrebuttable presumption of law. If I am a teacher of
Yes, who appears? Fukun? Yeah, notice will have to go.
Lordship, may kindly give an observation that the provincialization of respondent number 6 and 7 is subject to upcoming petition.
They heard Mr. BK Das. MS Henford. Standing council. Elementary education. Appears for the respondents. 1,
2, 4 and 5.
1, 2 also.
Yes, ma'am. 1,
1, 2,
2, 4 and 5.
4, 5. And district scrutiny, MSS Cornwall and government. Appears for the respond number 2. So extra copies. For petitioner to take steps for service of notice. On the respondents 6 and 7 by registered post ID within 1 week. Respondents are allowed to file affidavit, list up to 4 weeks. The provincialization of the services of the respondents. 6 and 7 shall be subject to the outcome.
Obliged. Item 14.
Each amending order of March 2023, 44.
Who is the order?
Find the order in page number 39. No, 23rd March 2022.
The notice to issue, Lords. I'm deprived.
That is just the notice to issue.
But Mr.
My name is A. Narzari.
A. Narzani on the council. She notice. Elementary, Mr. A. Foucault,
Foucault for one.
Standing Council Elementary Education. Appears for respondents, one. Only
One and four men.
one and four.
I appear for respondent number 2, 3, 5, and 6.
And Mr. S. Boral, in a standing council. BTC appears for
2,
respondents,
3, 5, and 6.
2, 3, 5, and 6. Extra copies. Petitioner to take steps for service of notice on the respondents. 7 and 8 by registered proceeding within 1 week from today. Respondents are notified. List of the audience.
Obligation.
15.
May please your lordship. The petitioner was initially appointed as stipendiary teacher, and thereafter, after completion of basic training, my lord, he was allowed to draw the regular time scale, my lord, by page 21, my lord, in extra F. Page 21 in pursuance of so and so, so and so. I ordered it demanded Minamai Mohanta iti welfare school basic training examination in the year is allowed to do the regular time. Thereafter, my lord, by page 23, my lord, he is converted to the temporary post, my lord. Once, my lord, a person is given regular time scale, my lord.
This under 2017 Act, isn't it?
My lord, so that cannot be without any proceeding, my lord. How can be a person with a regular time scale against the non-plan head?
You are aggrieved by this order.
Yes, my lord.
Why are you coming now? What were you doing?
My lord, that earlier period, that my lord, that
2021 order, why you are challenging now?
my lord, that my lord, some though this order was, my lord, that annexer F, that petitioner was not given the actual salary also, my lord. That's why, my lord, that the earlier period of salary may be given, and my lord, that period shall be treated as a
I'm
regular.
asking you, why are you
my
challenging
lord.
the order of 2021 now?
My lord, earlier, my lord,
Give an answer to that.
there is some late, my lord, that
Have you
because of
given
some
any-
financial
have you-
that
have
I
you
have,
given-
I
Have you
have
given any explanation in your writ petition?
explanation I have given, my lord. Explanation because of some financial hardship, he could not come at early, my lord. In paragraph, my lord, the salary is such a delay. 15, my lord, para 15, I have stated that the petitioner begged to submit that due to extreme financial crisis, the petitioner could not come to the approach this court at early from non-payment of the salary. As such, the delay filing of the case is not intentional. She is prevented by serious financial crisis. May condone the delay. Para 15, my lord.
Yes, Chitty.
Madam, the Paris space 23 madam. His accommodation order madam. This order has been issued by the expert committee madam.
As per the
As per the expert committee madam, those expert committee on the basis of the list madam. And he has madam accepted this accommodation as teacher madam, and with a condition madam, he will not claim the other benefits madam earlier. Their expert committee was constituted for minor verify the illegal or irregular teachers madam. He is the irregular or illegal teacher madam.
Okay.
He has
Let us see. First, Mr.
Sri Goswami.
MSS Vikia. The understanding council elementary education appears on behalf of all the respondents. Extra copies. This one was all file affidavit. List of the forms. 16.
Yes, this option. Prior to filing of this replacement milot, I had filed this replacement for the same cause of action milot in 2020 milot.
2020
milot. So due to some defects not arise during the pendency of the petition, I withdraw the same to file a fresh milot. This is a fresh petition.
When did you withdraw that?
Milot, I withdraw on milot 26/3/2025. Milot. The
What is that
second
order?
order I have not annexed. I've made the statement paragraph 2 milot.
Okay.
Milot, here is a petitioner is a milot, LP school teacher milot, and they joined in the 1993 milot. In 2007 milot, he has to transfer to the Borlongfar Model English LP school milot.
Where is that order?
Milot transfer order is I have not annexed milot. Milot, thereafter milot, there is a clash between milot, this Limasa and milot Karbi milot. Due to that reason, milot, the school also burned down. I could not attend the school regularly, my lord. So therefore, my lord, that disciplinary proceeding has been drawn against me. So cause been issued to me. I replied, my lord. Thereafter, I am not aware of that, my lord. I have been asked verbally to not to attend the school till completion of the departmental proceeding, my lord. My lord, thereafter, my lord, the departmental has been concluded, my lord. I have been dismissed from service, my lord. That has been not communicated to me, my lord. I thought I was in under suspension, my lord. So I met representation several times. Lastly, I met in the 2019 my lord, representation to the authority. They informed me, my respondent number 3, my lord, you have been already dismissed from service in 2008, my
What
lord.
is the dismissal order?
My lord. Lordship, Annexure 9, page 40, my lord. That is not communicated to me. Only on 2020 January, my lord, I got it.
Where's the inquiry report?
Inquiry report also I have not awarded. Only after that pending earlier petition, my lord, well filed an affidavit by the council, my lord. There I come to know this inquiry report, my lord. I think this is inquiry report is annex page 38. 33(8). Annexure 7. This is the opinion of the my lord inquiry report forwarded to the my lord authority in the last paragraph, my lord.
Yes.
My lord. Though, my lord, I am not entitled, even then, my lord, after this report, I have been not asked to file any, my lord, reprehension, my lord, regarding, my lord, this inquiry report, my lord. So thereafter, my lord, only I come to know in 2020 in the January, my lord, when that has been sent to me by registered court after my inquiry, my lord, regarding my lord, dismissal from service in 2008, my lord.
When did you receive this termination order?
My lord, in the month of January, my lord, I have made a statement, my lord, here.
January which year?
2020, my lord. Then immediately I filed a petition, my lord, after getting this order, challenging this. So due to certain defect, I would do the petition, my lord, and file a press to deliver it to my. This is the second. So notice may go, my lord.
Yes, you did.
Only 2 point, Lordship may keep it open, my lord. Second read petition after withdrawal of the first read petition, whether it is maintainable or not. This is the first question. Second matter, after 17 years, my lord, regarding the delay part,
both these two points, my lord, we filed
So
affidavit.
that's why I'm asking, where's
These
the
two
withdrawal
points,
order?
My lord, that is my
In
lord,
2008, he was dismissed from service, my lord. Now, after 17 years, another person is working there in that particular post. And he has confessed before the inquiry officer that he has engaged some other person to take the class by paying rupees 1,000. So he did not attend the school also. He was dismissed, my lord.
No,
So
but
those
this is-
2 points are there, my lord.
Third, Mr. M. Sarani. will also issue notice. Mr. J. Tutiel and outstanding counsel KAC appears for respondents, 1, 2,
5, my lord.
how about 3?
3, I'm appearing, my lord. 1, 2, 3, 4, and 5.
1, 2, 3, 4.
Only 6 is the private respondent.
who've been appointed in my place, my
Clerk
lord.
office. Petitioner to take steps for service of notice and notice of the 6 by registered. Respondents are allowed to file a list of the 4 weeks.
What's in there? Petition that, my lord.
Hmm?
That, my lord.
It will come. This is the first day notice is
My
my
lord.
17.
My lord, in this case leads to opening the Darpan portal, my lord. This year, this school only inactive of Darpan, my lord, but there is no order passed by the government, my lord. So let the notice may goes, my lord. In the meantime, your lordship kindly pass an order to open the Darpan portal because the the school won't be able to get admission, my lord. They are waiting for get admission. The students are waiting for get admission.
Lord, I am opposing you because 2024-25 session Lordship passed an interim order. Ultimately, that has been disposed of, directing in the director and the council to consider their case. Yet, my result has not come out. Whether they consider it in their favor or it is rejected, I don't know. Now, 2025, my lord, it cannot do. And now the school is not entitled. Earlier litigation, my lord, I have seen some documents. Government sent some documents and considered for it. That's why order has been passed. Now, in this case, nothing has been done. Now, petitioner has mentioned what teachers are appointed in 95 to 2005, where a school is established 2005. So, vexatious petition, Lordship Galaxy, page 8. So, therefore, notice
But
by
in this case, there are two
page,
sections.
page 7.
One is science and one is arts, my lord. Science is going on, my lord, and it was not inactive in the year 2024 and 25. This time they have make an inactive after passing the matriculation examination, my lord. Actually, this
page
case
7.
is covered by this honorable court's order.
No, it is not covered.
Okay.
Then let him
you take
file it.
instruction.
Yeah, I will
Yes,
install
my
this
lord.
text.
Next, fix next date.
MS Hertem,
Next week,
RTV, KJV, then the council for the petition. Mr. TC Tutel and the standing council,
Yes.
you are the standing
Or
council.
4 and 5, it should be 5, but it is 6 type. 4 and 6.
Standing council ASSEB. Shall receive instructions. to the matter.
My
When
lord,
you-
according to him, my school is bogus. If it
Okay,
is
what
bogus,
is-
then why it is opening up to
When do you want?
2025?
When do you want?
Next week, my lord.
Let
him bring instruction why
Friday?
my school has not been
Friday?
Next Friday,
activated.
no, Domala, next Wednesday. Friday also. It's okay, Mala, Friday.
Friday. 23rd.
Always.
Okay, MSB Das Leonard, standing council. Appears for the secretary. 18.
Oh, am I in it? But in this case, my lord, petitioner was appointed, she is appointed as a gate 4, my lord. Earlier, her husband is working, my lord, before the provincialization of the school. Suddenly he died, then they make a managing committee make a meeting, my lord, and took resolution and to appoint his wife, my lord, in the year 2010. And accordingly, she was joined, my lord. But her name has been
Notice
sent.
will go.
Yes, notice will go.
But
my lord.
MSK David and council.
Or lordship can dispose it of because since the your lordship can give direction to the district level, direction to the
Let us see.
DO.
what
Yes. How about that? Give it to them.
PK Boral and standing council, elementary division appears on behalf of all the
So that's
extra office. Respond to something. Bless. Is the performance.
19.
Well, the matter relates to the preparation of the gradation list as well as appointment to the post of headmaster of the respective schools. Now this petitioner, my lord, but pursuant to the advertisement of dated 2012, 1996 for filling up certain post of graduate teachers. But all these petitioners have participated in the selection process. In the said advertisement, the scale of pay as was granted at that time, that was also mentioned. Now, after due selection, the authority sometime in 2001 appointed each of the petitioners of Sibsagar district at a fixed pay of rupees 2,500. So these were challenged before this honorable court, and this honorable court, after hearing the parties, found that they are entitled to the graduate scale of pay from the date of initial joining in the post. And accordingly, the government has issued a notification on 6/2/2021. Lordship may come to page 68. Married. In pursuance of cabinet decision in the meeting held on 22/2021, the governor of Assam is pleased to notify and allow the benefit of regular time scale of pay as per ROP rules to following 189 graduate teachers who were appointed in fixed pay during 2001 and now working in different provincialized higher secondary school of Sibsagar district by arriving their pay notionally with effect from the date of their joining and shown against their names or from any other subsequent date, whichever is later. Now here, my lord, our name appeared at serial number 5, Kalpana Gogoi. Date of joining second column, Lordship will find, my lord, 4/4/2021. Then, my lord, petitioner at page 70, that is petitioner number 1.
Kalpana is petitioner number?
Kalpana is petitioner number 2, my lord.
And 69?
Then 69, this petitioner number 1. 67, my lord. Page 70.
Page 70.
Page 70. 67, Madhusmita Chutia, 3/4/2021. Then petitioner number 3 at page 74, serial number 158, 28/3/2021. So these are the date of
petitioner 3.
Petitioner number 3. Now, pursuant to that, the draft gradation list was prepared. Plus, you will find at page 83. Here our names are shown. Plus, you will find serial number 1206. That is petition number 3.
Which 83?
Page 84. The draft gradation the list at page 83, start from 83. Petitioner number 3 name appeared at page 84, serial number 1206. There it has been shown, Lordship will find, my lord, 26/2/2021, my lord. Fifth column from the left side, 26/2/2021. That is, this is the date on which the earlier notification was issued. At page 68. 26/2/2021. Whereas by this, the date of joining and the graduate scale of pay has been given from the respective date of joining. Now, 85 serial number 1246 is petitioner number 1. 1246.
Is also the same date.
Same date. Then petitioner number 2, page 86, serial number 1300.
Petition number?
This is 2, madam. This was the same date. So against that, my lord, page 89, we have submitted a representation stating that since advertisement also, my lord, we have joined, we are entitled to that. The High Court has also said, and pursuant to that, my lord, we have been given initial, so it should be corrected to, my lord, the initial date of joining. They did not do, my lord, anything. Rather, my lord, they have published a fresh, my lord, gradation list, draft gradation list at page 91. Well, here our name has been omitted. Our names are not there.
Okay.
They did not mention our names only. We have submitted again, my lord, representation as 114, but that is also not considered. Page 114, my lord, this representation is not considered. And then they have prepared a final gradation list at page 117.
Yeah.
There also, my lord, our names do not appear. Where the persons who are, my lord, junior to us in the respective schools, their names are, my lord, finding place. Not only that, the persons who have joined till 2023 or 24, their names are also included, but this petitioner's name have not been included. My lord, we have, my lord, submitted a representation, but nothing has been done, my lord. On the same day, based on this final gradation list, the chief will find at page 141. Same day, my lord. But the inspector of schools, my lord, has, well, circulated this final gradation list and allow the persons of the respective schools who are eligible to, my lord, appear in a particular date for the, my lord, competition for the selection to the post of headmaster of the respective schools. Now these schools are given at page 142. My lord, three schools, my lord, is at serial number 5 is 1. Serial number 5. Then serial number 61 and serial number 107. Now, as per this letter,
Serial number 167.
serial number 5, Amguri Halwating Mazru High School. Then page 43, serial number 62, Dugdar High School. And page 144, 107, Normati Girls High School. These are the three schools of the petitioners where the selection of the for the post of headmaster will go. And we are discharging, my lord, our duty as an in charge of that those schools because we are the senior most, my lord, teachers of that school. But because of, my lord, this, my lord, provisional gradation list, as our names are not appearing there, so, my lord, we are not being allowed to participate in the process, my lord.
কালি চেম্বার আহান একটু ফাইল পঢ়া একদম ইম্পর্টেন্ট ফাইল একটু এরকম বসে তোমার
In this regard, you are requested to circulate the final gradation list among the concerned teachers and allow them to attend in the document verification process to be held at TRG Memorial High School, Sipsagar, as per scheduled date and time enclosed here. So we are not able to participate because our names are not there in the final gradation list. Now, so far as rule 14, 24, and 25, this clearly gives a mandate that the appointment to the post of headmaster shall be promotion on the basis of seniority. Now, rule 24 and 25 prescribes how the seniority and the seniority list and the gradation list will be prepared. Now, our names are not included there in violation of those 24 and 25, and consequently, we are deprived our benefit under rule 14 to be considered for promotion. Therefore, I pray, that this notice may be go, but till that this finalization has not been taken place, we are still discharging at the headmaster of the respective school. So some interim protection may kindly be granted to us. They must.
Yes,
they
yes,
must
lawsuits.
include our names in the provision.
Lawsuit may turn to rule 14 lawsuits. What is the eligibility for the post of headmaster?
14 now.
14 2B lawsuit,
Which rule page?
page 36. Lawsuit. Table 2B lawsuit. He must have at least 10 years of teaching experience as graduate teacher lawsuit. B.
Rule 14, sub rule.
Table 2B lawsuit. He must have at least 10 years of teaching experience as graduate teacher. And lawsuit may turn to page 68, Annexure E. Page 68, Annexure E of the writ petition lawsuit. The notification they rely upon that they are having the graduate scale lawsuit. My senior friend read the first paragraph, lawsuit, second paragraph, lawsuit. The payment of enhanced pay shall be made from the date of issue of this notification. That they will get a graduate scale from this notification lawsuit, it's the date of this notification lawsuit. And no lawsuits and no area salary shall be admissible for the past service prior to issue of this notification. So
That is with regard to error salary.
no,
But
area
the graduate scale of pay
yes, lawsuit.
was with effect from the date of the journey.
Enhanced pay that will be made that will be pay shall be made from the date of issue of this notification. So for 26 to 21 they are getting the graduate scale pay and they are not completing that 10 years of service. Anyway, lawsuit. And moreover, lawsuit there's a in appeal lawsuit there is a provision of filing appeal under section rule 25 table 3 lawsuit. In case of finalization of
Here the graduation list, their names were in the first provisional graduation list, there was a mistake.
yes,
So they approached you.
lawsuit may kindly,
You issued another graduation list, removing them from the list at all.
no, lawsuit may
Then
kindly-
if I pass the final seniority list, how can that be?
lawsuit there is a provision of filing appeal. So they file an appeal against the provisional list annexure page 114. Where is the receipt lawsuit? They've annexed the representation, but where is the receipt? Page 114 lawsuit may kindly page annexure J. How can the inspector school will act upon lawsuit? Thereafter, the final graduation list was prepared lawsuit. Against the final graduation list lawsuit, there is a provision in the rule 25 lawsuit sub 3 lawsuit. The final graduation list shall be published with the due address of each objection, if any, by the appointing authority. Any appeal in this regard will be taken up by the next higher authority, that is the director of secondary education, in case appointing authority is the inspector school, and the secretary to the government of Assam secondary education, in case of appointing authority is the director. Here is the director is the appointing authority, and where they have submitted the representation lawsuit before the director himself lawsuit. Page 151.
Okay.
Let them file a proper appeal before the appropriate authority lawsuit as per rule 25 sub 3 lawsuit.
No, then, but you can't proceed with the three
No, they are not
schools.
following the rules lawsuit. At this time, let me take instruction lawsuit.
Page 146, that is submitted before the Director of Secondary Education.
150.
You take instructions and
Yes.
come back.
And
But Mr. PG Saipan,
and till then, no, let me take instruction first.
assisted by Mr. MS Nirula. Nirula Learning Council. Stop. How long will you take
Wednesday, no? Or not next Friday?
on
Nothing will happen.
on request made by Mr. SMT Chisti, Learner Standing Council Secretary,
Yes, secondary education.
Education, list the matter on
23rd. Next Friday. Only 1 year.
to enable him to receive instructions. Till the next date fix. The respondents are directed.
Lawsuit, that interim order may not be given at this stage lawsuit. Because they are not filing their proper lawsuit.
But
let
then
me,
something is not proper.
Lord, nothing will happen till Friday lawsuit. Let me take an instruction first. Then Wednesday lawsuit may kindly fix it on Wednesday.
21st.
Yes, 21st. Yes,
Then
I will get
maybe-
the instruction on the
Till
that day
then,
lawsuit
nothing
will-
should be done.
on that day lawsuit will consider for any interim order.
I have clearly stated in paragraph 23 that till that process has not been finalized, we are still discharging as the in charge of the respective.
Status quo as on today shall be maintained in respect of
Only these three petitions.
Petitioners school,
in
namely
respect of
paragraph 2, my lord, I have said, Nomati Girls High School.
1 minute. In respect of Amguri,
Lordship.
Halluwati Mustur High School, comma, Tuktar High School, and Namti Girls High School, all under the Sibsagar district.
Extra copy may kindly be served.
Okay, you finished two extra copies.
Item 59, motion.
May it please your lordship.
Yes.
My lord, in this petition, the petitioner.
Mr. Chowdhury, after 5 minutes, I can. Yes.
May it please your lordship. My lord, the disciplinary proceeding initiated against the petitioner is under challenge in this petition, my lord. For that, my lord, first I have to take you an order passed earlier by this honorable court, my lord, in 2017. That your worship will date it, my lord, page 66. Already starts at page 58. It starts at page 58, my lord. And the petitioner and my lord, along with other my lord teachers, filed this writ petition for their salaries. And my lord, resistance was raised by the my lord state on the ground that my lord, the regulation was not in order. Now, your worship may kindly come to page 66. The my lord finding of this honorable court. Page 66, paragraph 11, may I read it, my lord? On the issue involved in the present case, the views expressed in the case of Monta Mohanty, as alluded above, appears to have received some valuation in Constitution Bench, State of Karnataka. At paragraph 53, Umadevi 3, the apex court have held that insofar as the cases where irregular appointments, not illegal appointments, are concerned, the question of regularization of the services of such employees are required to be taken up as a one-time measure, and the same would be confined to persons who have worked for 10 years or more in duly sanctioned posts, but not under the cover of orders of the court and tribunals. The significant observation made at paragraph 53, which is directly applicable in the instant case, is that regularization, if any, already made but not sub judice, need not be reopened based on the judgment, and that there should be no further bypassing of the constitutional requirement. Without any doubt, the appointments of the petitioners had been made by the managing committee. However, regulation, whether irregular or illegal, has been made way back in 1999 in terms of paragraph 53, Umadevi 3. The same are not required to be reopened. Then thereafter, my lord, in paragraph 12 also, my lord, is reiterated, having regard to the facts of the case and the observations made in paragraph 53 of Umadevi 3 Supra. It would not lie in the mouth of the state respondents to say that since the petitioners had been appointed by the managing committee, such appointments are illegal and therefore they are not entitled to salary. More so when the regularization of service took place way back in the year 1999 and not having been disturbed until this date. The petitioners are indeed entitled to salary for the period that they have worked. It is not in dispute that they are in employment as on date. The issue remains as to from which date they can claim arrear salary. The said issue has been decided by a division bench of this court in Harendra Chandra Das versus State of Tripura, which lays down that relief of recovery of arrear for the past period has to be restricted to a period of 3 years. Accordingly, my lord, eventually it is a direction has been issued in paragraph 14 to take steps for payment of salary to the petitioners. Now, my lord, against this, a review application was filed against the judgment, my lord, and the review petition was dismissed, which your lordship finds at page 82. Against that, my lord, the state again filed my lord, an appeal, writ appeal. And writ appeal order, your lordship may kindly read, may like to read, my lord. Writ appeal order is at page 92. Operative part, my lord. 98 and 99, my lord.
paragraph 5. Page 98, my lord. I'd like to read, my lord, paragraph 5. The foundation of challenge laid by the appellant department to the orders under appeal is based on an allegation that the respondents, rate petitioners, procured the orders of regulation issue way back in the year 1999 by practicing fraud. However, it is an admitted position that till date, no steps whatever has been taken by the appellant department to rescind, cancel these orders of regularization. The assertion made by the appellant counsel questioning the veracity of the regulation order is unfounded when we peruse the contents of additional affidavits submitted by the respondent, along with which the documents pertaining to FIR number such and such are annexed. These documents indicate that FIR lodged by the DEO resulted into negative final report which has been accepted by the court concerned. There being no proceeding to revoke, rescind the orders of regulation issued way back in 1999, the appellant department is not entitled to withhold the salary and other service benefits of to the respondents. So, my lord, this writ appeal was dismissed. Against that, my lord, an SLP was filed. SLP was also, my lord, dismissed. That your lordship gates at, my lord, page 100. Now, that way, my lord, the order passed by the honorable single judge that has attained finality. Then, my lord, FIR was lost, my lord. FIR was lost after the my lord writ petition was disposed of, my lord. FIR was lost, and my lord, FIR your lordship finds at page 69. And against that FIR, my lord, final report was submitted. The ground taken was that my lord signature of the my lord the then DU was fraudulently obtained. So, my lord, the FIR your lordship finds at page 69, and the final report your lordship will get at page 73. Relevant, my lord. Page 74, my lord. Those are the findings. Starts at page 73, my lord, final report. Page 7, my lord, page 74, your lordship may come to the, my lord, third paragraph. May I read it, my lord? After registering the complaint, Moregaon Police Station inquiring upon all the employees of the Office of the District Elementary Education and putting on record their statements, it was seen that the District Elementary Education Officer himself made all the correspondence relating to WPC 268 of 2023, and even he himself provided the memo number of the letter unfolding the file, and at the time of his transfer, he took away all the documents along with him. The officers and employees of the office also said that in case of regularization of service of the accused teachers, the former education officer, late Lupur Sharma, also did the same, and there is no force on the part of the accused. Still, during the investigation, 29 different documents duly signed by the District Elementary Education Officer during his service tenure in 2013-14 were collected, along with this original status report, which was seized, were sent to the Guwahati Forensic Laboratory so as to compare the specimen signature. After due examination, the forensic expert reported that the signatures of the original documents as well as the collected documents are of the same person. So, my lord, there was no forgery, my lord. That was the finding. And that he seeks fresh investigation. Now, my lord, after the writ appeal was disposed of, my lord, dismissed, then, my lord, the Director of Elementary Education, my lord, sought to seek a re-investigation by forensic and provided new sample. That your lordship will find at page 101. And this application for re-investigation based on, my lord, new samples were also, my lord, allowed by the CJM, my lord. And thereafter, my lord, the forensic experts, my lord, they gave their opinion and in favor of the same, my lord. Earlier also, the forensic gave the same report that there is no other forgery. Page 187. That your lordship will find, my lord, at page 187. It starts at 187, my lord. It starts with 113. Page 187, my lord. Last two paragraphs. I'm reading, my lord. During the course of investigation, two number of office documents having admitted signatures of DEO Nupur Sharma were seized from the office of the DE Assam on 17/8/2014. The two documents having signatures of Nupur Sharma seized from the DE Assam Kahilipara on 17/8/2024 were sent to the Director of Forensic Science Laboratory Kahilipara for comparison with 17 numbers of regularization orders of the accused persons, wide number such and such. Then in reply memo, the scientific officer Bapu Kon Chaudhary, the Director of Forensic Science Assam, write memo number so and so, opined that the signatures in the standard documents and the signatures in the 17 number of regularization orders were written by the same person, Sri Nupur Sharma, FSL report number such and such. So, my lord, this was, my lord, confirmed twice that, my lord, there were no, my lord, no forgery. Then, my lord, what happened? After all this, my lord, an FIR was lodged that your lordship finds, my lord.
Again?
Yes, my lord. On a different charge, my lord.
On?
That is at, my lord, page 199. Now, my lord, new story is sought to be built up. Page 199. This is, my lord, filed by Block Elementary Regulation Officer. I would like to inform you that below noted person, Sri Rabul Huda, is a teacher of number 2 Boroimari MEM School, District Morigaon, that at the time of verification of documents to comply the Honorable High Court's order dated 5/12/2023 passed in contempt number so and so for release of salary, the headmaster of number 2 Boroimari MEM School has submitted the HSLC, your lordship will notice, my lord, it has been submitted by the headmaster. The HSLC and HS Provisional Pass Certificate mark sheet for the year 1995 and 1997, respectively, in respect of Labul Huda, the petitioner, on 19/12/2023. After receiving the said documents, the DE Assam forwarded the same to the Secretary Seba as well as the Secretary Assam Higher Secondary Education Council by letter number such and such, respectively, for verification of genuineness of the certificate mark sheets produced by the headmaster. Accordingly, the Secretary Seba and SEC has submitted that their report by letter number such and such, respectively, wherein it is seen that both the certificates and mark sheets of HSLC and HS as produced are not genuine. I was not, my lord, directed to produce any document. It was, my lord, some document produced by the headmaster. It has come to light that Rabul Huda managed to forge the above mentioned documents somewhere in Guwahati city, Assam, with some other public servants of Guwahati and Morigaon, etc., with criminal conspiracy, and he has used the forged documents to be genuine, and thereby he has committed cheating by furnishing forged documents. Now, my lord, so far as that direction to payment of salary, your lordship is aware, my lord, the matter has been coming before your lordship. They are yet to, my lord, fully comply with that order. Now, then, my lord, a charge sheet has now been issued to initiate a disciplinary proceeding. That your lordship will find at page 203. I am challenging this, and, my lord, the subsequent notice. This is issued by the, my lord, disciplinary authority, the Director of Elementary, Director of Secondary. Show cause notice to the petitioner. You are hereby directed to show cause under Rule 9 of the Assam Service Disciplinary Appeal Rules, read with Article 311, as to why any of the penalties prescribed in the following charges based on so, my lord, your lordship may skip and come to the charges at the next page. 5 charges have been, my lord, framed. Statement of allegations. Number 1, that you claim that you were appointed as honorary teacher by the school managing committee of number 2 Boroimari ME School under Lahorighat Education Block of Morigaon District wide managing committee resolution dated so and so But as per the Assam Elementary Education Provincialization Rules 1977, the school managing committee is not empowered and authorized to appoint anyone in a provincialized ME school. In view of that, the matter is abundantly clear that you got yourself appointed as honorary teacher of number 2 Goromari ME school in connivance with the school managing committee, in gross violation of the provisions of the Assam Secondary Education Provincial Rules 1977, and thereby defrauded the concerned authority. Now, my lord, this issue has already been, my lord, settled by the Honorable Single Judge and, my lord, the dismissal of the assembly. So this is not a charge, my lord, by twisting the words, my lord, they cannot have the same charge again, my lord. The second charge, your lordship will see, that you claim that your service as assistant teacher of number so-and-so's ME school under Laharigat Education Block of Morigaon district, which were regularized by the order dated 25/11/99, was allegedly issued by then DEO Morigaon Nupur Sharma. But as per the report dated 30/12/2012 of the inquiry committee headed by Mrs. B. Deori, Additional Deputy Commissioner, Morigaon, Sri Madhav Malakar, Treasury Officer, Morigaon, as members of the committee, the regularization order was stated to be fake and the purported signature of DEO Morigaon was forged. This has also, my lord, already been decided, and all these documents were there before this honorable court in the earlier proceedings. This has attained finality, my lord, that cannot be reopened. And the, my lord, forensic reports, my lord, have been, my lord, brought twice. And that has been confirmed. Now they are trying to reopen. Number 3, that you, along with some other accomplices, manufactured false and fabricated status report with forged signatures of Muhammad Abdul Rezak, the DEO Morigaon, and Kamakya Sil, Senior Assistant in the Office of the DEO Morigaon, in connection with your alleged appointment and regulation, and submitted it to the Office of DE Assam on 21/2/2014. In the said false and fabricated status report, you tried to establish that your alleged appointment and regulation were valid. But Muhammad Abdul Razak, the then DEO Morigaon, and Kamakya Sil, Senior Assistant in the Office of the DEO Morigaon, informed in writing that the signatures contained in the said status report dated 21/2/2014 were not theirs. Now, my lord, I'd like to draw your lordship's attention, my lord, when this the earlier FR was, my lord, submitted. In fact, my lord, it was indicated that action should be taken against that DEO who has lost the false FR, Abdul Raja. And, my lord, this has also been, my lord, already settled. They are trying to, my lord, reopen this. 4 is also, my lord, somewhat similar, that in connection with the fake claim and forgery documents of FIR, which was lodged against even 28 others, which was registered and numbered as Morigaon PS case number such and such under section 406, 468, 34 of the Indian Penal Code. After conclusion of the investigating officer submitted charge sheet against you and 28 others by charge sheet number such and such under section 2. Now, my lord, this matter is pending. This is, my lord, subject matter of the. The signatures are not put. Now they are alleging conspiracy. Now, my lord, now the forgery party is, my lord, now, my lord, put in such a manner that, my lord, you have made a conspiracy with the person, my lord, who signed the documents. Then, my lord, this is, my lord, the new one. This concerns the FIR that you have just read, my lord, clause 5, the charge number 5. During verification of the documents, your educational certificates were sent to the Board of Secondary Education Assam and the Assam Higher Secondary Education Council for verification, and as per the verification report submitted by SEBA, your HSLC mark sheet is not valid and HSC mark sheet is not genuine. In this connection, FIR was lodged against you before the crime branch of the police, Panbajar Police, and the same was registered and numbered as crime branch PS case number 11 of 23 under section 120B. So, my lord, this is the subject matter of the FIR, my lord. Right. Now, your lordship will also notice, my lord, in the list of documents, so-called reports, the reports, my lord, which they are relying, those have not been enlisted. And, my lord, serial number 8, your lordship will find, my lord, other documents. The documents based on which, my lord, these charges have been sought to be framed, those are, my lord, not part of the list of documents. And, my lord, there are some other documents which I do not know. So what happened, my lord? The petitioner immediately filed a reply to this notice saying that this disciplinary proceeding is not maintainable. Your lordship finds that at page 207. He has given a detailed reply saying that paragraph A, your lordship will find the show cause notice is not maintainable in law as well as on facts to the extent that the issue of my appointment and regulation of my service on the appointment by managing committee and the subsequent regulations stand decided by the honorable court in WBC number such and such. And he has taken all the other grounds, my lord. He has also stated that, my lord, it cannot be reopened. And therefore, my lord, he says that since this is not maintainable and you have not provided us certain documents, you give an answer to that. So without, my lord, responding to this, now this 224, the impure notice has been issued. But I'd like to point out, my lord, in the meantime, I was not intimated who is the inquiry officer, who is the, my lord, presenting officer. This was not intimated, but this letter was communicated to me, which I received on 8th of May. Hearing schedule on 16/5/2025, that is today, my lord, in connection with departmental proceeding drawn up against you. With reference to the subject cited above, it is to inform you that a hearing is scheduled on 16/5/2025 at 11 AM in the office of the undersigned in connection with the department proceeding drawn up against you. Therefore, you are directed to appear before the inquiry officer as per date and venue mentioned above, along with all relevant supporting documents. Now, my lord, this type of inquiry is, my lord, not to, my lord, provided in the service jurisprudence. Now, after, my lord, I submit a response to the to the show cause notice that this is not maintainable. They have to say, my lord, because I have, my lord, shown your lordship that all the four charges out of 5 charges, they have already been settled by this honorable court. So far as the 5th charge is concerned, the FIR is already lodged. So, my lord, if I have to disclose my defense, I'll be highly prejudiced. Your lordship knows, my lord, the principle that has been laid down by the Honorable Supreme Court regarding, my lord, initiation of a disciplinary proceeding when a criminal case is concerned, my lord. 2 aspects need to be, my lord, considered. One is that, my lord, whether I'll be prejudiced, whether the delinquent will be prejudiced, number 1. And number 2, my lord, whether, my lord, the serious questions of law and facts are involved, my lord. In this charge sheet, my lord, serious questions of law and, my lord, facts are involved because, my lord, they are trying to twist their language. And what has been directed by this honorable court not to reopen, they are seeking to reopen. And so far as the 5th charge is concerned, my lord, that is already a, my lord, a matter of investigation by the police. And if I have to disclose, then, my lord, I'll be highly prejudiced. Therefore, my prayer before lordship is that, my lord, your lordship will stay the further proceeding and respond to the, my lord, my writ petition. And the proceeding is, my lord, fixed today. But till now, my lord, a little while ago, my lord, my junior, my lord, consulted my client, my lord. He says that, my lord, have been asked to wait. Nothing has happened till now. And, my lord, how can my lord, disciplinary authority himself write to the delinquent that you come with documents? You have to prove your case first. You have to, my lord, adduce your evidence. Thereafter, allow me to cross-examine.
No, who's the inquiry officer?
Inquiry officer is, my lord, we do not know, we have not been informed, but here, my lord, it says that you appear before the inquiry officer.
Any presenting officer?
No, my lord, we don't know. We don't know.
Yes, Majumdar.
I have been told 2 things. I'll first. There was a reference to the acceptance of the final law. I'm not on the merits of the case, but the speech. Lordship will have page 80.
Page
80. The
80.
submission was that the FR had 80. That the FR was accepted by the trial court at some point of time. Page 80 is the order annexed by the appeared the complainant so and so appeared before the court and white petition number so and so 150 of 19 has objected against the FR submitted by the IO and wants to proceed with the case. Reduced with the case report. Considering the petition number 150 of 19, FR is rejected. Doesn't appear to be accepted.
Second. But the Indian bench order.
Yes, it
Clearly
wrote that it is accepted.
it
So
is
there was
clearly
some,
said.
either there was a miscommunication or a wrong document was produced, either there or it is here. I do not know. This is, I'm just showing what the rejected part is there. Second position is not, second position in law. If a charge sheet is issued and an inquiry is being proceeded on, till that point of time, there is no prejudice to the delinquent officer or the charged officer.
There's already a criminal proceeding against the petitioner.
The criminal proceeding is whether he committed a forgery or not. There's a difference. Whether he committed a forgery. If the document itself is fake or forged by anybody else other than him, even then, if it is a fake or a forged document, the use of it to obtain a job or to produce it before appropriate authorities is a separate charge, which is not complex, which is not connected. The Supreme Court judgments to the effect, I'm not bringing them all down. What I would put is, this petition I have received today. Just filed maybe day after day before yesterday or something. I have received it today. I would need some instructions. As stated by him, today was the date. My instruction is all the officers are waiting. He has not attended the inquiry till now. Lordships will have it on next Friday. I take it the date will not be fixed before Friday next for the next appearance. If I can come back with records or with judgments to show that this does not require any interference at this stage, Lordship will consider it on Friday. If Lordship feels on Friday that yes, it needs to be interfered, Lordship will do so on Friday next. A week's time, and I am assuring till Friday next, we are not proceeding with the inquiry. We are not calling him again.
No, this court will direct not to proceed with the inquiry.
But that would cause a difficulty at this stage. It would be
Till Friday.
Till Friday next.
Heard Mr. M.K. Chaudhary, London Senior Counsel, assisted by Mr. M. Datta, London Counsel for the petition. Mr. R. Majumdar, London Standing Counsel, Elementary Judicial Department.
Department of School Education.
Department of School Education. Praised for some time to enable him to receive instructions. The praise allowed. List on.
Will be for all the respondents.
23rd, is it?
Me.
23rd of May. Till the next Netflix. The departmental proceeding against the petition shall not proceed.
Further orders will be considered on the next.
The continuation of the interim order shall depend on the instructions furnished by the London Standing Council.
In the meantime, my learned friend will inform the, because the date is today, my lord, he will inform the further.
He has not attended.
No,
He has not done that.
He is there, he is personally.
That is what I said. And in fact, inquiry officer, presenting officer has been appointed. Letters were issued to him. His representation rejection has been issued. I was not bringing that on to there. I would like to come back on Friday. Okay. All right.
Item 20, admission.
Instruction from the Islam.
My lord, here this matter is to be removal from service, my lord. My lord, the petitioner was working as an assistant professor in physics in Gorgaon College, Simologuri. While he was in service, suddenly he was placed under suspension. The suspension order is Annexure B, page 14, my lord. Then thereafter, the inquiry was held. Show cause notice was issued, and in the show cause notice, he submitted his reply. Relevant portion of his reply is page 19, my lord. He was suffering from some mental illness.
Which show cause?
Show cause notice. Show cause notice is B, my lord. Annexure B.
Annexure B.
Yes, my lord. Annexure B is suspension order.
Suspension order.
The reply is, my lord, Annexure C, my lord. And the page 15 is the allegation, is the show cause notice, and with allegations, my lord, page 15, my lord. That is, your lordship may kindly see the charges against him. You are very unenthusiastic in taking your classes. You didn't explain clearly and properly about the syllabus topics. You are very irregular in attending your classes, though you put your signature in the class register, but left the classroom without taking any class. You used to come to your department very late, and sometimes after taking the attendance of the student, you left the classroom without giving lecture. You were non-cooperative with the departmental activities. You did not obey order of principal and governing body. So these are the charges, my lord. And the petitioner submitted his reply, my lord. And his reply is at page 19, my lord, where relevant portion, page 19, my lord. I have attended an inquiry committee there and could not attend rest, for which I regret. I was hospitalized to LGB Regional Institute of Medical Health from 17/5/2016 to 11/8/2016. The authority of the hospital certified me as better than before. Mention must be made that my father informed the principal on 31/5/2016 regarding my illness issues. I also informed the principal at 16/8/2016 regarding my inability to join my duty due to reception of suspension order. My lord, in fact, he was suffering from mental illness, my lord. And my lord, then subsequently my inquiry was conducted, my lord. And during inquiry also, it was found that the petitioner was suffering from mental illness or during that particular period for which he was absent, my lord. That is, my lord, reflected at page 26, my lord, of the inquiry report. The last para I'm reading, my lord. However, the presenting officer was requested to call government servant Dr. Manoj Kumar Sharma, giving an another opportunity to appear before the inquiry committee for hearing on the proceeding, and also suggested to call all those CWs if required for cross by the government servant on the next date fixed accordingly for the same. The copies of depositions of all those PWs along with the exhibits A, B, C, D are enclosed herewith, that the said two medical documents furnished by the presenting officer are enclosed herewith for consideration of the competent authority. So these medical documents were also considered, my lord. And the last para, my lord, last para, that is at page 28, my lord. The allegations from 1 to 5 are proved and established an ex parte against the government servant Dr. Manoj Kumar Sharma, that though as per the above findings of the inquiry committee, the allegations against the government servant Dr. Manoj Kumar Sharma has been established to be true, but during the period of inquiry committee also observed that the behavior and attitude of the government servant Dr. Manoj Kumar Sharma was to some extent indifferent in nature, which may be due to his said illness as shown in the documents number 6 and 7. So they also admitted that the petition
Documents 6 and 7.
6 and 7 are the my medical documents. These are not with me, my lord. These are with the records, my lord.
You have the records, Kapilita?
Yes, madam.
And subsequently, a removal order was issued by the director, my lord. In the removal order also at page 31 at the bottom, my lord, that from the deposition of PWs along with the perusal of exhibits A, B, and C, D, E, it is very much clear that all the allegations from 1 to 5 are proved. The inquiry committee observed that the allegations are proved, but also observed that the indifferent attitude may be due to his illness. So they themselves have admitted that due to his illness, his behavior was indifferent during at that particular time, my lord. Moreover, my lord, the inquiry was conducted by the college authority, my lord. The college authority, the principal, he is not the appointing authority nor the disciplinary authority, my lord. On the basis of the inquiry report of the principal of the, my lord, college, this removal order was issued by the director, my lord.
Yes.
Yes, my lord. Procedure for imposition of penalties. 9, my lord, the Assam Service Discipline and Appeal Rules, Rule 9, my lord. 9(4), my lord. On receipt of written statement. Rule 9. 4, my lord, sub-rule 4. Here in my book, it is page 130. On receipt of written statement of defense, or if no such statement is received within the time specified, the disciplinary authority may itself inquire into such charge as are not admitted, or if considers it necessary to do so, appoint for the purpose the board of inquiry by an inquiring officer. The disciplinary authority may nominate any person to present the case in support of the charges before the authority inquiring into the charges. The government servant may present his case with the assistance of any other government servant approved by the disciplinary authority, but may not engage a legal practitioner for the purpose unless the person nominated by the disciplinary authority as aforesaid is a legal practitioner, or unless the disciplinary authority having regard to the circumstances of the case so permit. So the inquiry must be held by the disciplinary authority or any person nominated by the disciplinary authority, madam. Here, the inquiry was conducted by the college, my lord. It was in fact, it was a preliminary inquiry, my lord. And it is admitted in their affidavit also, my lord. The respondent number 2 has filed affidavit, my lord, in opposition, my lord. And in para 7 of the affidavit of the respondent number 2, I'm reading, my lord. The deponent begs to state that the principal Gorgaon College has submitted information that the college authority has drawn departmental proceeding against the petitioner. They themselves have admitted that the college authority has drawn the proceeding, my lord. And it was only a preliminary inquiry, my lord. Preliminary inquiry is held only to find out whether there is a prima facie case for ordering departmental inquiry or not. And it is not a substitute for disciplinary proceeding, my lord.
How do you say it's a preliminary inquiry?
Because it was held by the college authority. It was not held by the disciplinary authority or the appointing authority by the director, my lord.
Yes,
And in one occasion, my lord, the council also admitted that that was a preliminary inquiry, my lord. And one more submission, my lord. The punishment is also, my lord, disproportionate because, my lord, the punishment, my lord, the charges, the allegations are minor charges, my lord. And for that, he has been removed from service, my lord. And here I have relied on a decision of the Honorable Supreme Court, 2014 1 SCC 82. The lawsuit may carry use, my lord.
yes.
My lord, so there is no criminal charge against the petitioner, only minor charges are there. My lord.
Which para are you referring to?
My lord, I have tick mark, my lord.
Yes, sir.
However, in this case, the penalty was imposed upon the petitioner under Rule 7 of the Assam Service Disciplinary Ethics Rules. While the kindly have with page 426.
Discipline appeal rules.
Yes, madam.
Rule 7.
Uh, 431 is the nature of penalties. The penalty was imposed upon the petitioner under Rule 7 of this rules, my lord. Now, this rules provides that if any government servant is aggrieved by imposition of penalty under Rule 7, then there is a remedy, my lord, under Rule 15 to appeal before the appellate authority, my lord. 15 is 440, my lord, page 440. Rule 15 appeals against order imposing penalty. The government servant may appeal against an order imposing upon him any of the penalties specified in Rule 7 to the appellate authority specified in this behalf. In the schedule, there shall be no appeal against the order to the appellate authority. Okay. So my submission is, my lord, since there is a provision.
Where's the schedule? Where's the schedule?
Schedule is, my lord, page 450.
We're having different books. Here the disciplinary authority is the
Director, my lord.
the appointing authority.
Yes, my lord.
And who will be the appointing authority?
The
Appellate
Director of
authority?
Higher Education. Is, my lord, Rule 9, my lord. It is clearly given, my lord. The government servant, for the purpose of preparing his defense, permitted to inspect or take extracts from the official records as may be specified. If so, for reasons to be recorded in writing in the opinion of the disciplinary authority, such records are.
Who is the appellate authority here?
One of the secretary, my lord.
Which? Where is it provided?
Lord, I think it will be come under 78, my lord, point number 78. All non-gazetted posts under control of head of the department. Other than the appointing authority is head of the department, then appellate authority is secretary of the department. So my submission would be, my lord, since there is a provision.
No, one thing is that if the procedure was correct, then that thing will come. Was the procedure proper when the
But that
disciplinary
will-
proceeding
that
was
will be looked up-
initiated against the
Look into by
petitioner?
the appellate authority, my lord, because authority has power to look into whether a proceeding has proper proceeding has been followed or not, my lord. That power is there to the appellate authority, my lord.
What does your affidavit say?
Sorry, my lord.
Affidavit.
Then in this regard, my lord, I'll place one judgment, my lord, for alternative remedy, my lord. Which may I read one para, my lord.
Affidavit para 7, my lord, they have stated that college authority has drawn up departmental proceeding.
Regarding drawing up departmental proceeding, my lord, there is judgment also I have brought, my lord, which says that the departmental proceeding or proceeding can be drawn up by the other authority also. It has to be superior of the incumbent, not necessarily the appointing authority.
Where is
It's a
that?
recent one.
What is this about?
This is what this is my lord regarding alternative remedy, my lord. Para 11 para would be my lord 6. 6, my lord. Then internal para 49, my lord. Under para 6 of the 4th page. It says that, my lord, if I may read, my lord, Article 226 is not meant to short circuit or circumvent statutory procedure. It is only where statutory remedies are entitled entirely ill-suited to meet the demands of extraordinary situations, as for instance, where the very virus of the statute is in the question, or where private or public wrongs are so inextricable mixed up, and the prevention of public injury and the vindication of public justice required, if that recourse may be held to Article 226 of the Constitution, but then the court must have good and sufficient reason to bypass the alternative remedy provided by statute. Purely as matters involve the revenue where this is not important. We can take
Here in this case, my lord, statutory rules have been violated, so the writ is maintainable, my lord.
the next, my lord, 5 is, in our opinion, the order which was passed by the tribunal directed the so and so. The High Court ought not to have exercised its jurisdiction under Article 227 in where the provisions for alternative remedy contained in the Act. My submission is, my lord, since there is an alternative provision of alternative remedy available in the statute itself, so before the petitioner, before approaching this honorable court, my lord, ought to have approached the authority, appellate authority, and then come to this.
It says may approach, may or may not file appeal, my lord.
My lord, that cannot be shall, my lord, because shall will be.
And what is the other case?
Then, my lord, the other case says that the inquiry can be conducted by the other authorities also, but it has to be superior to the incumbent, my lord.
Where is that? Where is that?
My lord, just give me one sometime, my lord. I'll. May I have the copy, my lord? I have it marked actually there. I think second page or third. Underline.
You don't have an extra copy.
I'm sorry, Madam, it was there in mobile. Somewhere. I'll hand over, my lord. May I read, my lord, once? It says that, my lord, article, my lord, article, T11 does not in terms require that the authority empowered by that provision to dismiss or remove an officer.
You read below that, come below that.
Yes, my lord. Article,
No, beyond, next page. You do one thing, Tabitha get 2 copies, in the lunchtime, we'll take up to
Yes.
get 2. That judgment is against you.
I'll. Well,
Lordship, Lordship, if I may, your Lordship, Lordship in item number 42, my lord. Can you be 42? Can you be taken up on Tuesday, my lord, next Tuesday? It's a compassionate appointment of course, but I'm not keeping well actually, that's right.
Why councils don't keep well, they can go. Courts can't go. It's not fair.
Next Tuesday.
Normally Friday lawsuits.
Oh, yeah, Friday too.
42
42, next
on
Tuesday, my
request made by Miss.
21. 20. This is a compassionate appointment actually, that's what. Highly obliged.
Item 20.
My lord, I'll rely on para 21, 22, and 33 of the judgment, my lord.
No, the issue here is, as the director is the disciplinary authority in the appointing authority, whether he has delegated the power to the college.
My lord,
Does the report indicate anything?
the report doesn't indicate anything, my lord. I'm very fair, my lord.
Just take some instructions on that issue, otherwise we can close the matter. No need to go any further. Third MS, speech out in the constable. Is there double
Yes, that's my lord.
that's, and then the standing also higher education. Shall take instructions. This after 1 week, 2 weeks.
One,
My lord, the date may be fixed, my lord.
27th.
27.
that's all.
Right.
Item 60, operator.
Oh, 60 was not upgraded.
May I start, my lord?
Yeah, for the petitioner.
My lord,
Oh. Yes.
my lord, my client joined NIT Silchar in the year 2010, my lord.
And we are the counsel for the other side.
You know, I sent WhatsApp messages to the other side. I can show it to you, but they are somehow for the last 8 months, nobody is appearing, nor they have given any counter agreement. My lord, my client is suffering like anything. Now, what has happened, my lord? They are going to infringe my right again. They have issued a notification, my lord. Here is the
Oh,
copy down.
yesterday you were saying that the mention was made.
Yes, my lord, I mentioned with informing the other party. Other side, SP Chaudhary, my learned friend. I requested him also through WhatsApp also.
yesterday, then today also, today morning. This is happening for the last 8 months, my lord. Now my problem is, my lord, the other side, NIT Silchar, has announced again the recruitment to the post of professor. My lord, for the last 15 years, I have been denied this post. My students, my juniors have been promoted and they are bossing over me, my lord. My lord, again, they have announced. I have downloaded from the website, my lord.
So where's the other side?
My lord,
You catch all of them and come. We'll take up after some time.
after some time, my lord.
You just check up if Mr. Chowdhury is there or not.
Yes, my lord.
Otherwise, in the absence, it will be difficult.
Oh, sir, Junior to SP Chaudhary has come.
Oh, you have. Oh, Chowdhury's.
Yes.
The affidavit is coming or not?
Affidavit is coming, Lordship. In the next week, we will filing it.
4 weeks back, it was.
Affidavit is
coming
other
to the court.
Lordship, but the thing is that the concerned person who is out of station, who is the authorized officer, is out of station because of some official work. So he'll be coming on Monday, but the next week we'll be filing.
Madam, for the timing, this matter magistrate, this recruitment process, at least for the post of professor, my lord, they have completed everything just for announcement.
There is
They are
no
waiting
IA
for
file, Lordship.
they have already approached my colleague, my case, my side, and he has prayed for an adjournment.
This is the
Just for this purpose. And he has just insulted me like anything. He said that he would come to the court and again say,
What insulted?
is the advocate on record from my side? He has prayed for an adjournment without informing the client and without my permission.
Who?
My client's advocate.
Okay.
Advocate on record. He has prayed for the adjournment, knowing full well that his client's right is going to be infringed.
Sought the adjournment.
The counsel for the petitioner, sir.
Counsel for the petitioner without. We have already, he has made a complaint to the complaint. Yes,
Are you the counsel?
He is also the counsel.
Yeah, kindly read it, kindly. Just have you got it. This is very unusual, my lord.
No, this is item number 60.
This is something.
Something very-
This
but-
is something between you, not.
Okay, but for the timing, my humble prayer is, unless this matter is straight, the recruitment
See,
for the post of
this,
officer.
this notification was of 1/3/2025.
Yes, my lord.
Correct.
Thereafter, we have been trying to.
And the
approach the court.
last date for submission of forms is 10 days after it is notified in the employment news.
My lord, it is written employment newspaper. So many candidates have complained about it. There is nothing called employment newspaper. There is employment news. And my lord, it has not been published in the employment news. This is a hushing up game, my lord, and it is designed to deprive my client from his genuine promotion. He is a member of OBC, my lord.
Mr. Chowdhury,
Yes, Lordship.
what is the status of this?
I have to obtain the necessary instruction with regard to that.
For
This
the timing, my lord,
this matter may
let
come
it
up
be
in the
stayed.
next week, because what I'm.
This court is seized with the matter, let it be stayed, my lord.
No, I can't stay this
Well,
unless I get
Exactly,
proper
yes,
instructions.
exactly, Lordship. Because what I'm saying, what I've
Because
submitted,
this you are handing over to the court.
exactly, I have not been
You
given
could
the
have
copy.
brought this by way of filing an IA.
IA.
And
My
then
lord-
this court could have taken judicial notice.
My lord, I have prepared an IA. If you're
You
not
file it.
surprised, I'll file it.
File it.
File it for the
Because
timing
see,
then.
what the Chowdhury is saying is that the concerned person who's supposed to swear the affidavit is coming on Monday
Monday.
and he'll be filing it by Tuesday. isn't
Yes,
it?
Lordship.
By
Everything
the
is
time
ready.
the promotion and everything will be clear, my student will come, say, okay, you come here, this, that. My client,
Are-
for the last 15 years, he is in the same post, associate professor.
That will consider the matter. That will consider the.
Mirror for the timing, stay may kindly granted. Otherwise,
This will consider only on the next day. We'll
in
take
the
it up
meantime,
on.
if he's agreed by any
Mr.
notification, yes.
Chowdhury, what we can do, we can take this up on Monday. For the purpose of
No,
this.
he has not filed any IL also with regard
We're
to that.
filing it today itself, tomorrow itself.
Okay, file it, serve a copy on the other
Exactly.
side.
For the timing, it let this matter, since
He is
the
repeatedly
honorable
saying all
court
the
is
time.
seized with the matter, no order for promotion.
A
For
proper
the post
procedure
of
is to be
officer.
followed.
No.
This
Once
is
you have
online,
order,
this is an
proper
online
procedure is taken.
application. This is an online application.
Milord,
This is an online application.
yes, Milord. I cannot apply because I have not been promoted to the post of professor. If I apply it now, my right from 2017 will be infringed. I have paid for that.
This is the admission on his part, Lordship. He cannot appear in this particular notification.
Your
We
good name,
object.
please.
Milord,
Your good name, please.
Nripendra Krishna Roy, N.K. Roy, Milord.
N.K. Roy.
Yes, Milord.
Your name is not here.
Milord, I'm coming as a senior advocate. If your lordship pleases, I will file Wakalatnama tomorrow itself.
Okay. You file your Wakalatnama.
Milord,
Have you signed the Wakalatnama in this writ petition?
no, Milord.
How are you appearing in the court?
I am on the
Under
basis
which
of,
authority?
initially, Milord,
Which
I am saying,
authority are you appearing?
initially, my learned friend Devajit Senapati was the advocate on the record. He recused himself because according to him, this very languages are very harsh. I said, the languages are as harsh as the commission of the crime. Milord, after that, somebody, Kotuki was appointed. After that, whoever is getting appeared with, they are accusing themselves. Well, this is a very peculiar situation. And I am coming to fight for the client, but I have no power here. Immediately,
Just authority he is submitting yours. He has not filed the Wakalatnama.
because as a senior advocate, I will file it. I'll file it. If your lordship allows me one time, tomorrow I'll file it. I'm asking the client to file it.
Are you a designated senior?
No.
Milord, in Kolkata, I'm supposed to be not authorized, but I'm sitting.
I'm asking you, are you a designated senior?
No, not designated. I appear as senior. No official bar designation is there.
Okay.
Milord.
You're entering appearance today. Is it?
Yes, Milord.
Mr.
Nripendra Krishna Roy, N.K. Roy.
N.K. Roy, Land Council. Submits that he has instructions to appear on behalf of the petition. And will be filing his Wakalatnama within
next week.
Within 1 week.
Your Lordship, in this case, actually, I am the engaged advocate. They have with the concern. They are appearing in this case.
No, the thing is that he has submitted one paper before this honorable court.
What paper?
Making certain allegation against the previous
How
counsel.
this possible, Your Lordship?
First of all, at least some communication is to be given to the previous counsel. Without serving any copy, he is supplying it to the court. This is absolutely unethical on your part.
You are appealing for the counsel.
Exactly, he was the previous counsel, Lordship.
Milord,
that is
what authority is having?
If this thing is going to go on.
Yes, Your Lordship.
And
his client has sent a
no, there is
WhatsApp
no
message.
letter on
wasting
part of
the
the
time
letter.
of this court.
We don't require.
Wasting the time of this court.
Exactly, wasting the time of the
Your
court.
Lordship.
He is not the authorized person.
I am
Without
insulting
Wakalatnama,
nobody.
without any authority from
I
the
am,
client, he
I
is
am
appearing and
fighting
he is
for
making
the right of
submission.
my client, Milord.
Under
I have
which-
been appearing for the last 8 months. You kindly see the records.
Without Wakalatnama, he is making
It's all
some
right.
sort of
On
allegation
the
against
basis
the
of
counsel.
his power, I was appearing.
No,
He has been recruited by me through a common acquaintance from
Okay.
Chhattisgarh. Milord, I have been appearing for the last 8
Strong
months.
exception should be taken.
1 minute.
For the last 8 months, I have been appearing. This question was never raised.
Mr. So-and-so, Leonard Council submits that he has instructions to appear on behalf of the petitioner
Submit for us.
and prays for 1 week time to file Wakalatnama. Stop. Mr.
That's Your Lordship.
S. Roy, Leonard Council, also appearing on behalf of the petitioner, submits that he has not been instructed by the petitioner that he is being withdrawn from the case. Correct?
They are seeking Your Lordship NOC from me.
Oh.
Today they are given a message.
They've taken an NOC from you, asking for an NOC.
Yes, NOC.
They have asked me, but I told him that they clear my dues, Your Lordship. Without clear my dues, I
Don't,
cannot.
please,
Yes.
please don't make this argument inside of court.
Yes.
These matters will be settled outside the court.
Mr. S.P. Chowdhury, Leonard Council appearing on behalf of the respondents.
Yes, respondents.
Submits that he'll be filing affidavit within 1 week. Accordingly, list the matter after 1 week.
Mashallah.
Item 6.
Height of
Item 6, I have received the instruction lordship making and record my statement that nothing, just completely stop the proceeding lordship. Nothing will happen. Let it come on Wednesday next lordship.
Okay,
I'll
heard
file-
A.R. Bhuyan, learned counsel for the petitioner. On request made by SMT Chief Steel and standing counsel for the list the matter on 21st. It
I'll
is.
I'll file my
it
affidavit by
is-
Monday.
It is also submitted. Okay, then we cancel it. Mr. SMT Chief Steel and standing counsel secondary division department submits that he'll be filing his affidavit on or before 19th of May 2025. He further submits that what
The
steps
selection process for the purpose of promotion in.
I have a
headmasters
telephonic
in
conversation with the
Lakhimpur.
inspector of school. They said they have stopped the proceeding. They will not do anything lordship. They have all complete stop till
that till the next returnable date.
yes
No steps would be taken
regarding that
by
process.
by the respondents with regard to the
Promotion, Miller,
with regard to the promotion
to the post of headmasters, Miller.
to the post of headmaster in Lakhimpur district.
Lakhimpur district.
Stop. Recording the submission made by the standing council, secretary division.
21st.
This matter on 21st.
Yes.
March.
Online.
On that day, my interim may be considered.
Yes, yes.
Well, obliged.
Item 21, admissions.
This matter, Lordship, higher education has today morning, they have filed their affidavit,
Lordship.
Lordship. We need some time to go through it, Lordship. Lordship, may kindly fix this matter on 30 of May, Lordship, so that we can apply the
You have higher education is respondent. Respondent.
respondent higher education, Lordship. They have filed their affidavit today morning, Lord.
Respondent number given.
Respondent number two,
Two lordship.
Director of Higher Education.
Respondent. Mr. S. Bhuyan, learned standing council higher education submits that the respondent too has filed counter affidavit this time. Registered to verify and place the same on report. List the letter again on 30.
Okay, deeply applied. 22.
Salary, no? May I
In this
please
case,
have
I
the
have
lordship?
received instruction, madam. Madam may come after 2 weeks, man. In the meantime, I will try to.
If received
I
instruction,
say,
heard Mr. A. Bhuyan, learned council for the petition. MSS Tutia, learned standing council, elementary education department submits that she has received instructions. And prays for 2 weeks time if I compare.
only I am praying for a date, Miller.
Praise allowed. Date. This.
June, first week of June.
9 June.
Obliged.
23.
No, this matter, my lord, relating to petitioner was earlier terminated and thereafter by judgment and order, lordship will find page 41.
1 minute.
Order of this honorable court by order dated 23/4/15. This court. And in page 42.
We have received instructions from some time. They are not.
You have received. Okay, we'll give you.
So, Malaka,
Yes, not learned.
date may fix my daughter, but there.
MSN Fukan, learned
Element.
standing council elementary division department submits that she has received and prays for 2 weeks time. By counter. Please. come.
Date may fix my lord, otherwise.
That will come.
Obliged.
24 and 25. Lordship, in this matter, on the last occasion, we were asked to get our instructions in Lordship. Might not be e-file bearing number 222604.
1 minute.
Pertaining to
You forwarded it to the finance
Finance
department
for concurrence, ma'am, for concurrence, so.
for regularization of the service.
Next, my lord. So, my lord, no, for getting concurrence, my lord, for the regularization. Therefore, my lord, sometime we seek some time because, my lord, since it's gone to the, since this letter is of today, we have received it today, man. That it is in process, my lord. So sometime may be given, my lord, so that I'll give a copy to the other side, my lord. So that, my lord, it can take shape. Three weeks time may be given.
But MS
J Paul.
J Paul, learning council to the petition. Yes, J, if learned
No, sir,
standing
date may
council,
be fixed.
learned standing council. Elementary education department. Submits. That the department had earlier moved to the finance department. For regularization of services of the petitioners. In both the writ petitions. However, the finance department has made some observations and returned the files. Thereafter, the e-file has been re-endorsed back to the finance department, seeking conference. The accordingly praised for, how much time do you require?
Chip, at the moment, 3 weeks, my lord, because since.
But
I was
date
received-
may be fixed, no, sir, otherwise.
To enable him to receive further instructions. Praise the Lord. This 11 June.
28.
My lord, the matter relates to the grant of one advance increment to the petitioners, my lord. So
No
last
affidavit
occasion,
has
they have
come.
to file affidavit.
Chishti. And Chalia Gogoi, I think. Chishti, what are the instructions? Increment.
Yes, ma'am.
Elementary. Lordship, I think. 24, that's instruction I have not received yet, Lordship.
But Mr. N. Haq.
Yes, sir.
Yes, have learned consecutive petition.
Sir, yeah.
Oh, S.R. Barwea, learned consecutive. On request made by Assembly Chishti, learned second, standing council secretary resolution department.
Elementary, Lordship. It's elementary.
Is it elementary?
Yes, yes.
No, no, it's secondary.
Huh?
It's secondary.
Secondary.
Kiman by item.
Huh? 28.
It's secondary.
Yes, yes, secondary.
Standing council secondary education, 2 weeks time is allowed. To enable him to receive.
The date may be.
List after 2 weeks. These are 24 matter, I'm not fixing dates.
My lord, similar matter has been disposed of by this or by this or not.
Okay. You produce it the next day.
Item by T. Yes, yes, ठीक है, couple. 30.
May I please, Lordship? Lordship, this is a petition for compassionate appointment, Your Lordship. The father of the petitioner died in the year 1991, Your Lordship. Initially, the mother of the petitioner applied for compassionate appointment, Your Lordship. Initially, mother of the petitioner applied, but it was not considered, Your Lordship. Subsequently, when the petitioner attained majority, Your Lordship, he made an application, but it's not, has not been considered, Your Lordship. Lordship may find the annexure 7, page number 29. This is the application made by the mother of the petitioner initiated. And page number 40 is the son who got major, Your Lordship, made the application for the second time, Your Lordship. The petitioner asks to appear before the district authority, your lordship, for producing all the documents. Unfortunately, I could not annex that. I am submitting it right now, your lordship. Only that, your lordship, there was a SLC is, DLC is not in session, your lordship. It was on 8/9/2024, your lordship. It is, my name is at serial number 5, your lordship. I have appeared with it.
Then what happened?
Yes, I don't, because of there is a, as this office memorandum has come, your lordship, DLC, you know.
Who
Yes, sir.
appears? You give him a copy of this during. You take instructions on this. You take instructions on this. Mr.
R.H. Chaudhary.
R.H. Chaudhary, learned counsel for the petitioner, submits that the petitioner, along with five other persons, were directed to appear before the ACS Assistant Commissioner and Executive Magistrate Hailakandi on when?
Same date, your lordship, 8/9/2024.
On 19/9/2024. Along with all original documents, certificates, etc. Stop. He further submits that the petitioner appeared before the concerned authority on 19/9/2024. However, the outcome of the said however, till date, the petitioner has not been informed with regard to the outcome of the meeting held on 19/9/2024. Mr. B. Dewey shall receive instructions in the matter. Regional government shall receive instructions in the matter. How long?
Lordship, May on 30.
List after 2 weeks.
31. In this matter, now I cannot appear on behalf of the petitioner. Our board will appear, my lord. Again, the government, my lord, will be difficult for my part. So let it be on Wednesday, my lord.
Okay, Mr. B. Gogoi, learned counsel for the petitioner, submits that he will not be able to appear on behalf of the petitioner due to the fact that you have been appointed as additional advocate general Assam.
So let it be on Wednesday.
He therefore submits that the matter will be listed on when?
On my lord, 21st. 21/5.
Okay, no, don't say he therefore. According to list the matter on 21st.
32.
Last revision, my lord, 3 weeks time was given to file a affidavit, my lord. I did the filing.
Hello, we have received instructions for some time.
You have received?
Yes.
How about?
I am appearing for respondent of 5 I already filed, my lord. Respondent of 5 already filed, my lord.
But you are Islam learned counsel for the also heard Mr.
H.R. Ahmed.
H.R. Ahmed, learned counsel for the respondent. Para MS and standing counsel, elementary education, suppose that she has received instructions. And place for 2 weeks time to file a complaint. List up to 2 weeks.
33.
May I please, may I please, your lordship? My lord, an speaking order is under challenge, affidavit is required, my lord. Notice was issued on September, my lord.
It's coming for the
My
second
lord,
time.
on our mention, my lord, it has come up. Some time may be given to them, my lord.
Elementary.
Elementary.
But yeah, Boyan learned counsel. Mr. A. Fukant, the standing counsel elementary education is allowed 3 weeks time to file complaint.
Lord, again, I am praying for a date, my lord. Second week
The
of June, my lord.
2024 method.
Second week of June, my lord.
No, list after 2 weeks. You can mention it. That.
34.
May it please your lordship, my lord. Lordship, earlier on 27/9/2024, lordship has been pleased to protect the petitioner, my lord. Affidavit is required in this matter, my lord.
But Mr.
BK Das.
BK Das and the council. Mr. S. Guyan. The standing also higher elevation is allowed. 2 weeks time. To file counter. List of 2 weeks.
My lord, interim order may be directed
Interim
to
order
continue.
pass earlier to continue.
Deeply obliged.
36.
May it please your lordships. Lordships, we had filed our affidavit in reply to the affidavit in opposition only today, your lordship. Lordship, therefore, it is not on part of the record. Lordship may take it up some other day.
Mr.
T. Kashyap, your lordship.
T.
Kashyap, your lordship.
I appear for respondents 3 and 4, my lord.
Then the counsel for the petitioner submits that they file reply to the counter filed by the
Respondents 3 and 4.
respondents 3 and 4 this morning. In registry to verify the place as list after 2 weeks.
2 weeks, your lordship.
Would it be next Friday, my lord?
Next Friday, many pieces ago.
Yes, she is continuing, my lord, beyond her retirement age. There is a status quo in her favor.
List the matter on 26th.
26.
Monday.
Fine.
Mr. P.T. Nair, the council appears on behalf of the Cotton Union. And MS. Appears on behalf of respondent number 5.
Lordship, status quo may be continued, your lordship. There's an interim.
Status quo order passed, interim order passed to continue till the next.
Deeply obliged.
37.
In this case, leading counsel is make another court, my lord. Can we time pass for time being, my lord? We received the instruction, we would file the affidavit, my lord. Regarding the, my lord, is
Heard R. Islam, then the counsel for the petitioner. You are appearing for the,
no, my lord. Yan Sharma is.
okay, heard R. Islam, then the counsel appearing on behalf of Mr. N. Sharma. Then the counsel for the petitioner. Mr. T. J. Shukia, then the standing counsel, TAC,
My lord.
submits that he has received instructions and prays for
3 weeks time to file.
3 weeks time to file contract. Praise Allah, list of 3 weeks.
I'm appearing for 1, 2, and 3.
Ms. Pidas, then standing counsel appears for the
Secondary division.
Obliged.
38.
My lord, in this case, my lord, my area salary about 26 lakhs is not paid.
Granted to file the affidavit 25 meter, my lord. For the first time it is coming.
Not for the first time, my lord.
Second time, my lord.
On the last occasion, my lord, instruction waited, that was the thing. So, my lord, it is from long time this area salary is not paid.
area salary, don't take such a long time.
Yes,
Cynthia.
My lord, the petitioner is working at that period of time, my lord.
3 weeks
Yes,
time.
3
3
weeks.
weeks. Heard Mr. M.A. Sheikh, learned counsel. On request made by Mr. J. Chukia, then the standing counsel case 3 weeks time is ago to file contract. List after 3 weeks. MS go over. Then counsel appears on behalf of Mr. Silvaro for the response number.
My lord, area salary matter, my lord, may I pray for a date, my lord, after 3 weeks?
25 meter.
My lord,
You mentioned.
my lord. Obliged.
39.
Lordship, I apologize, your lordship. With regards to item number 36,
1 minute.
lordship, there is some difficulty on the fixed date. Lordship, may it be 9th of June. May it be changed.
Item 30.
36, your lordship.
Item 36. What did I say? List after?
List on 26.
26 it was, but there is some difficulty. your lordship.
9 June.
9
June.
9 June.
Much obliged.
Deeply obliged.
May I please a lordship? Kindly clear the lordship last order lordship. I am not getting the salary lordship.
Here I have only received my earlier, we have produced of 29 April, my lord, instruction. Here, my lord,
29th of April,
April, my lord.
2025.
My lord, that instruction I have received only, my lord, they have filed a Miss J case education in the, before the education tribunal. My lord.
There's a case pending in the education tribunal. It's South Salman.
As per judgment, my lord, dated.
Yes. That was, this court on the first day also this court has noticed that.
My lord, this was ordered at 1/8/2024, page 37.
No, 6/2/2025.
My lord, true, my lord. That is pen, they have filed, they have approached the tribunal, my lord. That is pending.
Heard, Mr.
AK does not read it.
AK?
Does.
Learned Counsel. Mr. PK Barwal, Learned Standing Counsel. Elementary education is allowed. How much time?
My lord,
2 weeks
3
time. 2 weeks time. This 3 weeks.
Obliged.
40.
But in this case, I have received instruction manual. What's your affidavit is not been filed? After
She's
3 weeks.
Heard MS?
P. Hazarika.
P. Hazard. MS
SUTM.
STT and MS Standing Counsel. Elementary.
Elementary division.
Elementary. Education department supports that she has received instructions. And praise for
3 weeks, my lord.
3 weeks time to file for. 41.
My lord. My lord, the matter here pertains to the case of sexual harassment of the petitioner by the respondent number 4. My lord, the complaint is at page 18, but I implore your lordship to go to page 22. Page 22 is the inquiry report of the Internal Complaints Committee. The recommendation, my lord, is at page 26.
1 minute.
That is the recommendation. The bottommost paragraph, my lord. The ICC, after its inquiry, concludes that the respondent's acts and behavior of approaching the aggrieved woman, based on the statements of the complaint and the documentary evidences, has amounted to sexual harassment of the aggrieved woman, leading to a hostile work environment. The ICC strongly condemns the sexual harassment committed by Dr. So-and-so, who is the respondent number 4, my lord. The ICC members present arrived at the conclusion that the allegation against the respondent has been proved, and the ICC recommends the executive authority of the KK Hendik to take action for sexual harassment as a misconduct in accordance with the provisions of the university rules applicable to the respondent, and that the executive authority, my lord, this is placed before the Board of Management. The executive authority shall take such action within a period of 30 days as per the University Grants Commission Regulation 2015 from the receipt of the inquiry report by the ICC. This is at the inquiry report, my lord, dated 4/12/2024. Thereafter, my lord, at page 29, which is the impugned minutes of the proceeding. Page 29, my lord. Now, because they want to shield a sexual harassment, a sexual offender, this is what the university has come up with. Item number 1, page 30.
Page 30, my lord. It starts at page 29. Page 29 is the letter sent to the presiding officer of the ICC by the registrar. These contain the reasons for not taking actions as per the ICC. In the last meeting, at the last paragraph at page 30. In the last meeting of the Board of Management held on 20/12/2024, the matter related to the executive authority of the university to act upon the recommendations of the ICC as regards to inquiry done about the complaint lodged by the senior assistant against Deputy Registrar Administration was placed. The BOM resolved that the legal opinion as regards to the course of action upon the recommendations of the ICC on the matter needs to be taken. The legal opinion is the second paragraph at page 31. In view of the aforesaid factual and legal metrics, I am of the considered humble opinion that in the eyes of law, the aforesaid inquiry report of the ICC is not acceptable, my lord, for the executive authority of the KK Hendik, particularly in view of non-maintenance of the principles of natural justice, and the said report cannot be acted upon by the executive authority at all, including the recommendations of the ICC incorporated therein. Thereafter, the second paragraph, the legal opinion was received on 6/1/2025, and before the legal opinion was received on 1/1/2025. The respondent number 4, the appellant herein, had filed an appeal against the ICC inquiry report. Then, my lord, will kindly come to page 32. Paragraph number 4. Simultaneously, the Honorable Board of Management members may kindly note, as per the mail sent from DR so-and-so, has lodged a defamation case, a title suit. The respondent 4 has filed a title suit, a defamation against the petitioner for filing a sexual harassment case. And the entire matter, including the complaint letter as well as the ICC's communication dated 12/9/2024, asking for the reply to the complaint letter, are now sub judice. It is stated that by an order dated so-and-so, the matter was admitted for hearing. As per the respondent number 4, my lord, the copy of the title suit starts at page 33. Page 33 is the title suit copy. And my lord, the prayers start at page 53. Page 53 is the prayer. For recovery of a sum of rupees 1 crore only from the defendant as damages and compensation on account of defamation to the plaintiff. The defamation to the plaintiff purportedly has been caused because she lodged a complaint of sexual harassment against the same person. Now, this case is pending. Now, pending this title suit before the lower court below, the authorities have not acted upon the appeal. My lord, the sexual harassment at workplace has a mechanism at section 30 that talks about filtering out of all frivolous complaints. Now, the moment a complaint is taken for its value and an inquiry is conducted and a finding is found out, that it qualifies that threshold that it is not a frivolous complaint. And my lord, this is a civil defamation where truth is an absolute defense. Now, the university, for whatever reasons they may have, they want to shield a sexual perpetrator in the same university without disposing of the appeal, because disposing of the appeal will give a fresh ground of cause of action for the petitioner to approach this court. My lord, you'll see the conduct which they have failed to act upon. My lord, will kindly come to page 28. That lady has given the phone numbers of the family member of the respondent number 4 who has called and threatened her. Page 28. Page 28 is the letter that after the inquiry committee report was out, my lord, the second paragraph, I'm taking names here, that madam on 6/12/2024, one Miss Ajanta Kolita, who happens to be a relative of the deputy registrar, has called me on my office and requested me to withdraw my complaint. Then on December 7th, I received a call at home from the wife of the deputy registrar, who pressurized me to drop the complaint. Now the authorities say that they have taken interim measures, so the appeal cannot be disposed of till the title suit is disposed of. The title suit might take a time longer than the entire service tenure of the respondent number 4. My lord, a university is a state instrumentality. They cannot shield a sexual offender. My prayer that I've sought for in the writ petition, my lord, is not much. It is not even adversarial to the university. My lord will kindly come to page 15. That's the prayer. Prayer number 1, I'm willing to let go of. Prayer number 2. A writ in the nature of mandamus shall not be issued directing the responding authority, especially number 2, to dispose of the appeal. Let them dispose of the appeal. They say that natural justice, principles of natural justice was not followed. The registrar was given a hearing. The colleagues of the petitioner was given a hearing. The petitioner herself was given a hearing. The ICC was constituted as per the norms, as per the act. Now they want to sit on top of the appeal till the title suit is disposed of in the next 10 years. That is the stand that they have taken, based on the legal advice given to them by the Irvani Council.
Fukan, you are appealing for?
Yes.
For the Board of Management, my lord, and my senior friend.
And for the university. Now, if your lordship look
How
at
about the respondent for?
Parliament,
Private.
Respondent for?
I am for the university and I.
Steps have been taken.
One went.
Notice has gone out.
It has gone. Now, your lordship, my learned friend has argued that there is an order against the respondent number 4. Now, my lord, respondent number 4 has already filed an appeal. Now, that appeal is pending. The question is this: in the meantime, my lord, there is a title suit. Now, in the title suit, my lord, the petitioner has already appeared. He has submitted the jurisdiction of the trial court. And my lord, she can file her written statement. Even my lord, further.
No, but that is with regard to defamation. But in the appeal filed by the petitioner,
Yeah.
why can't you dispose it?
That won't be any difficulty, my lord. The question is, my lord, I have seen the contention raised in the appeal. Is, my lord, there is a violation of natural justice in the sense. My lord, they have given the copy of the complaint. In a just, hasty manner, the entire my lord, transaction took place. They have given the complaint and regarding the evidence given, that copy was not given to the delinquent. My lord, so therefore, my lord, the entire approach of the proceeding was suffers from serious illegality in the sense.
The ICC.
Yes, because the right of cross-examination was not given to the delinquent. So this is the first point. Ultimately, my lord, the appeal will be allowed. What I say is as a lawyer, I'm saying. Then the second question would be, my lord, if there is a violation of principle of natural justice, obviously, my lord, that will be shaped. Now, secondly, my lord, since the title suit is there, it may be a question that is a point for defamation and all that. But there, my lord, since they have surrendered to the jurisdiction of the court, they can file their written statement. And if they want to contest by taking all these grounds, we can file a counterclaim in terms
No,
of.
that's a different thing that the petitioner will do.
Yes.
Why can't you just dispose of the complaint? That's all.
That we can do, maybe. There is no problem. But what I'm saying.
Dispose of the complaint, produce a disposal order, then we can close this petition.
My lord, this is arising out of the same complaint, and since the title suit is pending, both the side will give, my lord, it's a wider jurisdiction. They can adduce evidence. Here it is summary proceeding, my lord. There they can extensively they can stand their case. Both the side can give their evidence in extensive manner. Here, my lord, in a ICC, how the cross-examination will be done is not in the regular court. The way it is done is not like
No, that what act is that?
My lord, I have given a copy.
This call, my lord.
Prevention of
Sexual Harassment of Women at Workplace, Prevention, Prohibition and Dismissal Act 2013 with rules. My lord, may kindly come to page, paragraph number, section 14. Section 14. Section 14, my lord. Punishment for false or malicious complaint and false evidence. This is the threshold that the complaint had to cross through. Now, your lordship will kindly come to page 25. page 25 of the petition, my lord. Page 25. These are afterthoughts.
Okay. Then
Only
what
disposing
we
the-
can do, we can direct you to dispose of the
Yes.
appeal.
My lord, one thing my junior is saying that service is not complete in
Upon
regard to.
respondent number 4.
Oh, is it?
Yes.
Then how is it coming in the admission?
I didn't see that, my lord, I'm sure.
My lord, respondent number 4 with utmost humility.
Is the main party.
He is not the main party.
How
He's
can you
not-
say that?
I
Then
can
why you are
saying that
making
because-
party?
No, it's a pro forma defendant. He does not need to dispose of his appeal against himself.
Ye main aggrieved party.
He is not the main aggrieved party, my lord. It is a process which has to be followed as per the act.
I wonder how he can say that he is not a necessary party.
Appeal of respondent 4 is pending. He has filed like this.
Service, as I understand, was completed.
The complaint is against respondent number 4. And it's surprising that they have made it a proper.
The obligations do not lie on the respondent number 4 to dispose an appeal against himself. That is strange, my lord, and unfortunate that the university is shielding a sexual offender.
Make some limitation on your argument.
Sexual offender is roaming freely in the campus.
There is a legal system that will take care of it.
Oh,
Your Lordship, kindly see respondent number 4 is termed as pro forma
Yes.
respondent and he is the aggrieved person.
there was no notice issued.
There is not one.
On 3/3/2025, when notice was issued.
The respondent number 4 is totally
Respondent
unaware.
notice was not issued on the respondent.
That was argued, my lord. That was argued that he's a pro forma respondent because the obligations of the prayer at page 13, they do not lie on the pro forma respondent. It is for setting aside and disposing of the appeal. Merely the appeal may go in his favor. It seems it will go in his favor. So we have no dispute to that. The respondent 4 is going to claim the same thing that he has filed in the complaint petition, the defamation.
No,
And the complaint is against whom? Against the respondent number 4.
So file the dispose of it.
Respondent number 4 notice need not go.
Need not go. It's a pro forma respondent. We have made a submission to that effect that the obligations of the prayer which has been sought for, they lie on the university to dispose of the appeal. Even if it is in his favor, it is not argued by us that it should not be in his favor. At least it will give us a cause of
My
action.
lord, I don't know why such type of argument is placed. First thing, my lord, complaint is made against him. He is the person aggrieved. And you say by writing is a pro forma respondent.
Yes.
Merely saying pro forma respondent will not become pro forma respondent. He is the main respondent here. And whatever the order comes, it will be against him. Natural justice was violated by the ICC. Now, once again, they want to show that here also the same thing will take place.
Page 25, my lord, if it is violation, natural justice.
Okay, then we'll do one thing. We'll pass an order. We'll direct them and then when can you dispose it off? 2 weeks?
Yes, within a month.
1 month? So we'll list up.
Yes, ma'am.
After 1 month, we produce the disposal order. We heard Mr.
M. Sharma, my lord.
M. Sharma and the counsel for the.
My lord, before your lordship, I said, I am appearing for the board of management, my lord, respondent number 2. My lord, I'm be allowed to place the orders passed by the lower court, my lord.
No, I'm not going to that. I'm just saying, consider the appeal filed by the respondent number 4 and thereafter pass appropriate orders.
My lord,
After that, we'll see what happens to this petition.
The hesitant in
my lord, Title 6 main, my lord, the complaint dated 22/8/2024.
See, there is a complaint
My lord,
under the sexual harassment in the workplace.
my lord,
All right. ICC took up the matter, made this recommendation,
my lord,
and then it was placed before the Board of
management.
Management.
my lord,
Correct.
my lord,
Meantime, the respondent number 4 filed an appeal
my lord,
saying that there was violation of principles of natural justice and some other grounds. Yeah. So that appeal is still pending. On the one side, number 4 has filed a defamation case against the petitioner. Let the defamation case go on, but let the appeal be disposed. That's what I'm saying.
But my lord, in the appeal, my lord, there is one section regarding section 28 of the Sexual Harassment Act. May I place that provision?
Yes.
Section 20.
Yes, what do you want to say in this?
Section 28. In
No,
the
I have
appeal,
it. I have it. I have it.
section 20.
Yes.
My lord, there is a plea in the appeal that since the matter is pending before the learned lower court, so my lord, this as per section 28, the Board of Management should not take up the matter. Section 28, my lord. Act not in derogation of any other law.
Is there any order from the concerned court directing the Board of Management not to dispose of the appeal?
No, my lord. But the case was admitted, my lord, and the
Maybe.
other side has, my lord, prayed for filing the written statement. And the
Let that go on. Here, let us see what happens in the appeal. After that, we'll see what the fate of this writ petition. That's all.
I'll be grateful, my lord. That is all that I seek.
and without notice to the private.
Of course, that part is there, but then
My lord,
He's representing the
Technically-
university, not
technically,
not the respondent number 4, by the way.
being a court
Okay.
officer, my lord, I should point out the provision of the law. my lord.
Mr.
M. Sharma.
M. Sharma, let us listen to the petition. As well as Mr. S. Tata, Leonard Senior Counsel, assisted by MS. S. Musari for the respondents 1, 2, and 3.
One.
One and three.
1 and 3.
1 and 3.
I am for respondent number 2,
And Mr. PG Fukan,
for respondent number 2.
you're the standing counsel.
Yes.
You're the standing counsel. Krishna Kanta Hindu University, State Open Union for the respondent. Stop. You filed the appeal where before whom respondent before?
The Board of Management, when they filed, this one number 4 had filed, the averment, my lord, is at paragraph number 12. At page 9.
The Board of Management
Yes.
of the Krishna
Krishna
Kanta
Kanta,
Hendik Open University is directed to dispose of the appeal filed by the respondent number 4 against the ICC recommendation made on 14/12/2024. Stop. Let such appeal be disposed of within a period of 1 month. Can you do it in 1 month?
My lord,
I think you can finish it in 1 week.
yes, sir, 1 month. As per provision, my lord, it will be 1 month.
Within a period of 1 month. So provision is the exterior time only. Before that also you can dispose it.
1 month will be better.
Okay, 1 month.
Your lordship will kindly fix a date after a month, just to.
Give a date of 1 month.
19.
19. I'm grateful, my lord.
Item 43. Lordship, here in this matter, they furnished me the soft copy yesterday in the evening part. Accordingly, I have sent. Now today I have talked with them. They showed that 2 proposals they had sent. One for revision and
What proposal? From you?
From the DEO. Department. For one.
Why are you pointing your finger at me?
Yes, one for revision and the other for commutation. Now what, first of all, they sent the revision proposal in hard copy. Then later on, they sent the for commutation. Now commutation has been met with. Now with regard to revision, it needs to be sent again through online, that Kritegya NIC. That NIC, they are getting, some problems are there. Even they had coordinated with the concerned departmental official also. So the status is that it is not working, that particular portal. So I pray for some time. That is what right at this moment.
Give him 2 weeks.
3 weeks, because mechanical.
And their process, but the stipulated period that give the benefit to the petitioner.
The system is not working. That is what.
It has already been given by the
It
concerned
has not
department.
been working for quite some time, isn't it? As per this court's order also, we have
No,
noticed that
that,
it was not working.
simultaneously,
You have not made any attempt to let it work. Is it?
it is not within my jurisdiction. That NIC, one system is there. So
At IS cycle and the council for the petition. Mr. B. Dugan, then the government, it prays for another 2 weeks time.
3 weeks time.
3 weeks time, to enable him to receive. Praise a lot, Mr. 3 weeks. Mr. D. Bhattacharya, then
That's 405.
standing council appears for the accountant general.
Let me fix my lord. Cancel the benefit.
25 meter,
Cancel the benefit, my lord.
give a date of 3 weeks. 12th of June. Item 44, orders.
It be pleases you lordship. Here, your lordship, we needed to file our affidavit. Your lordship, on the last occasion, I took time, your lordship.
Is there a private respondent here?
No,
Why is it coming for orders?
my lord,
Affidavit is not filed. Affidavit has not filed, your lordship.
affidavit from the,
Your lordship, kindly grant us 2 weeks time, your lordship.
I
one,
think
my
it should
lord,
come up in the admission column.
headmaster,
How about respondent number 5? Notice is served.
sir, and he submitted affidavit, my lord.
Respondent number 5.
5 years. It's already. Headmaster. Submitted.
Okay, heard Mr.
No.
AG Atia, Learned Counsel for the petition. MSP Das, standing counsel, Secretary Education Department. Is allowed how much time?
2 weeks time, your lordship.
2 weeks time to file contract. List of the comments. Who appears on behalf of this? Just check the buckler from. List after 2 weeks. This is not a buckler number. This is the. No, this is a petitioner's.
Here we go. 5. 5 are complete.
Respondent number 5 has not filed buckler number.
No.
That's the.
Who's the counsel appearing for
My lord,
respondent 5?
B. Sanda. B. Sanda, I received the affidavit on 25,
Okay,
2024, man.
List after 2 weeks.
Date may be fixed, my lord. And I can see earlier also, my lord.
11 June.
All right,
Deep to
11, 6.
deeply of this.
Item 45 to 49.
Well, these matters are listed for orders, my lord. As regards of item number 48 and 49, well, the service was
I think 48, 48 and
Not
49
complete.
service. For now, 5 is not complete. There is the office note. Madam.
49 and 49. Perhaps they have taken today, my lord, as they have said.
You've taken steps.
Yes.
48 and 49. Yes.
48 is 197.
There is the office note. Madam.
You've
There's a
taken
flag.
steps by registered post
Yes, Lord.
today.
Yes, Doctor.
The saffron color is the flag mark. Office note is notification. Flag mark. Office note. It will be.
And 49 also?
Same.
Same.
Okay. MS
Thank you, Doctor. On behalf of the board,
A. Gogoi,
Jai Bogoi.
J. Gogoi, Learned Counsel appearing on behalf of Mr. B.B. Bora. Learned Counsel for the petitioners in WBC 1978 of 2024 and WBC 2079 of 2024 subjects that they have taken steps for service of notice on the respondent number
5. Both 5.
5 in both the petitions today. Stop. Accordingly, comma, list the matter after 4 weeks.
May I pray for a date, my lord?
This is 24 matter. Okay, 23rd June.
Obliged, ma'am.
Item 50.
May I please, your lordship, proceeding. As per office note, lordship, service report is related to the respondent, sole respondent. Lord.
When did you take steps?
So it has taken.
If you want, then. Can you take first steps?
Yes, lordship.
Majumdar, this Chief Secretary is Ravi Kota.
Yes. Now he is. Now he is.
Ravi Kota.
Yes, Chief Secretary.
Just wanted to confirm.
Chief Secretary.
Okay, you take first steps. A petition is directed to take first steps for service of notice on the sole respondent by registered proceeding within 1 week. Publish the matter again after 4 weeks.
51. Lordship may kindly see the order dated 18/3/2025. By the Lordship may kindly see the order dated 18/3/2025 passed by the Lozima Court. Lordship, the Lozima Court, although Lordship, they have received the notice, the Lozima Court directed us to take fresh steps. Then we took fresh steps. Then Lordship, there is another order.
11/4/2025.
11/4, Lordship. Service is completed in respect of the contempt matter. But despite service, Lordship, they have not appeared.
No, I will appear.
Lord- Lordship, and there is some standing counsel, Parangan Goswami had appeared in the writ petition, Lord. Assam State Textbook Corporation.
Okay.
No.
I will try to get Lordship.
You are appealing?
No, Lordship, for one, I can appear, but Textbook Corporation, that he's also secretary to ours, Lordship. I will inform him, Lordship.
In the writ petition, Lordship, when this writ petition was moved,
Managing Director.
He's also secretary to Education Department. I will inform him, Lordship. Lordship, I can take it up next week. I will get the instruction, Lordship.
Okay, heard Mr. SK Das, Learned Counsel for the petition. Mr. SMD Chisti, Learned Counsel. Appears on behalf of the
No,
respondent.
one time I can appear, and two, I will inform Lordship.
And praise for how much time?
PN Goswami,
2 weeks after 2 weeks.
When they go into this instructions. Praise the Lord.
Only a copy of the contempt petition that may be furnished as so that I can send.
You furnish a copy so that things can move faster.
52.
52. Lordship, on last occasion for instruction, Lordship, by elementary education.
How about the respondents notice? Complete?
Completed. That's all.
Hmm?
Completed.
Size opportunity.
Respondent number 9.
She's not checked the office note.
Check.
Do you have an officer by a midday meal rice officer?
I think it's under the SSA, man.
No, here doesn't respondent 8. It says midday meal rice officer.
DEO.
The midday meal rice officer of the DEO. I don't think there's an officer called midday meal officer.
I don't think so.
There is
First DEO.
full print. Must be a printing.
9 is complete. 9 is complete. Third MS.
T. Begum.
Dear Begum Land.
T. Begum, Lordship.
Dear Begum Land Council. Peruse the proceedings of the Lawazima court dated 12/11/2023. The notice on respondent number 9 shall be deemed to be complete. Yes, does.
Lordship, we have not received any.
He does, then the standing council elementary education is allowed.
Secondary, Your Lordship. I am appearing secondary for respondent 3 and 4.
I'm appearing for one.
And 1.
No.
1.
Okay, Mr.
Three and
A.
four.
Furqan, then the standing council secretary.
Elementary for respondent number 2, my lord. 2, 4, and 5.
And here,
I am appearing for 1, 3 and 4.
that is secretary.
Secondary.
And I'm
And
appearing
he is
for
for
elementary also.
Mr. A. Furqan, then the standing council elementary division.
My lord.
department. And MSP does, then the standing council secretary division are both allowed 3 weeks time to file the respective affidavits. List of the 3 weeks in the election.
53. Please, your lordship. In this matter, my lord, this matter is covered by another order, my lord. Here I have challenged an order by which managing committee of 2 school has been dissolved, my lord. And another writ petition was also filed for the another school, and that writ petition was disposed of, setting aside the impugn order, my lord.
See, council, have you seen the Lawazima court's order? 14/5/2025.
No, my lord, I have not checked it, but there are
Notice has not gone. You directed to take steps
my
for
lord,
respondent
matter
number.
which is involved in this. For a moment, my lord,
Will the respondent number 5 be required to be heard or not?
the matter is related between the inspector of schools and the, my lord, managing committee, and respondent number 5 is the member secretary. But the instructions which was brought in another case, my lord, that instruction shows that the managing committee was dissolved without following the due process. I have the order. For a moment, if your lordship may. And that instruction is also applicable in this case also, my lord.
Is that correct, thus?
My lord, kindly have a look at page number 3, my lord. Paragraph 8.
Earlier with petition, Your Lordship, there is 5605 that has already been disposed of. And Your Lordship, this one is Your Lordship, I have no brief, Your Lordship.
For a moment, my lord, kindly have a look at page number 3, paragraph 8, my lord.
Yeah.
The content of the letter dated 24/3/2025 issued by the Inspector of Schools, Lakhimpur District Circle, North Lakhimpur, is reproduced herein below as follows. Subject instruction in regard to the IS so and so in WSN so and so. Sir, with reference to the subject cited above, I have the honor to state that SMDC of Dawlatpur Higher Secondary School and Tinthengya High School, here is the Tinthengya High School, my lord, were dissolved on receipt of public allegations and instructions from the higher authority after due approval of District Commissioner Lakhimpur. No notice was issued for the concerned SMDC prior to dissolution of them, my lord. And on the basis of this instruction, that writ petition was disposed of. And disposed of setting aside the impugned order.
This is which school?
This is Tintingia High School, my lord.
I need to obtain instruction.
My lord, and on the basis of that instruction, this.
Here
impugned
it says
order-
Dowlatpur Higher Secondary School and
Yes,
Tingtingia High School.
I am for Tintingia
Two.
High School.
Two,
Two, my lord.
no notice.
No notice, my lord. And on the, had the same impugned order, my lord, two school was dissolved. And that order was set aside by this honorable court in the other writ petition.
I remember this case. I think I issued.
Yes, your lordship. Your lordship has passed an status quo order. my lord.
Is it correct?
Yes. Here, I have been filed by NJ Khatania for vacating of, for Lordship may kindly take it up on Monday, Lordship. He is not present today.
Monday
Lordship.
now it's all full.
Or
How
Wednesday,
many cases are?
or Wednesday, Lordship. Because then I have been filed by Mr. NJ Khatania.
In both cases, I has been filed, my lord.
Yes, your
And
lordship,
actually,
I do
earlier-
remember that thing,
yes.
your lordship, NJ Khataniar is appeared, your lordship.
in this
One,
case also
I
earlier-
also appeared in that matter, your lordship, and pertaining to that, your lordship, since government, one direction has obtained instruction particularly, your lordship asking whether it has taken or not, your lordship. When was that?
You appeared in this case.
Yes, your lordship, I do remember.
And you
do re-
produced this document.
Yes, I produced
Yes.
this document. And
That
it
document was,
This
is
letter
also
was-
applicable to this writ petition.
Yes, my lord, because the
right
letter
now,
clearly
your
said.
lordship,
my lord.
pertaining to this 588-524, I
Heard
don't have
Mr.
the-
M.I. Hussain, learned counsel for the petition on request made on behalf of N.J. Khatania, learned standing counsel. Elementary,
Second.
secondary education, this the matter on 21st.
Item 54.
Thank you.
May I please your lordship?
Mm.
Lordship, in this matter, as per Loazima order dated 14/5/2025, service upon respondent number 9 and 10 are completed, lordship.
I am appearing for respondent number 10.
Yeah.
I am fine appearing.
Anybody for 9? Who's 10?
For 10, my lord, I am for 10.
Oh, 9 is school SMC.
10 is my lord Motilal Chauhan. Private bank.
You appearing for the first time today?
Yes, sir. Whatever. I will file for
Okay, Hurt MS,
P. Kakhlari.
P.
Kakhlari.
Kakhalari, letter counsel. Peruse the proceedings of the Lawazima Court dated 14/5/2025. The notice on respondent 9 and 10 shall be deemed to be complete. Stop. Para. Mr. K. Bhuyan, learned counsel, enters appearance on behalf of respondent number 10. And prays for 2 weeks time to file counter affidavit. How about the official respondents?
Lordship, I'm appearing for respondent number 3 to 8 on behalf of Mr. J. Chuti for the KAAC.
A similar prayer is made by MS
V. Shohei, Lordship. V. Shohei.
V. Shohei. Learned counsel appearing on behalf of Mr. J. Chutia.
Lordship.
The standing case stop. The prayers are allowed. Release the matter after 2 weeks in the admission call.
Keep your Lordship.
55.
Lordship, I'm appearing on the respondent number 8 and 9.
MST Begum.
3 weeks time may be granted, Lordship, to file our affidavit in opposition.
None appears for the petition. Peruse the proceedings of the Lawazima Court dated 14/5/20. The notice on respondents 6, 7, 8 and 9 shall be deemed to be complete. Your good name, please.
That filters lordship.
You are appearing for?
Lordship, 8 and 9, but we have also received instruction to file Ukarnama for 6 and 7.
Okay, so you are appearing
All the
MS Vindas, London Council. Appears on behalf of the respondents 6, 7, 8 and 9. And prays for how much time?
3 weeks time.
3 weeks time to file Vakalatama as well as counter. Praise the Lord. Least up to 2 weeks in the admission call.
56.
Yes, oh my God.
I believe.
Hmm.
See, in this matter, Lordship, notice was not issued to respondent number 5, Lordship.
What is that?
As per Lozima report, Lordship. Other services completed, Lordship.
Who's respondent by anybody appearing?
No, Lordship, notice was not issued, Lordship. As per order dated 7/3/2025, Lordship.
How about 6?
6 is completed, Lordship.
6 is complete.
Completed, Lordship. Lordship, what happened, Lordship, as per order dated 7/2025, Lordship. Only notice issued to respondent number 6, Lordship. Lordship.
Huh?
Lordship, at present, Lordship, notice may go to respondent number 5, Lordship.
Notice not sent to 5.
Lordship.
Third, Mr.
B. Bogu, my Lordship.
No, no, counsel for the petition. Issue notice on the respondent number 5. Petitioner to take steps for service of notice on respondent 5 by registered post ID within 1 week. Oh. Peruse the proceedings of the Lawazima Court dated 28/4/2025. The notice on respondent number 6 shall be deemed to be complete. List the matter after 4 weeks. In the meantime, respondents may file counter.
57 and 58.
Yes.
If your lordships kindly take up the IA, page 19, the petitioner is agreed by this order, my lord.
Page 19.
Page 19 of the IA, my lord.
This IA is in where? In a review.
This IA is in the review. My lord, what happened actually in this matter? By this page 19, serial number 4, one Arpana Neok, she has been posted in a post which was meant for me in the year 2013. Serial number 4, your lordship will kindly find. So this post was created for my provincialization in the year 2014. That post was lying vacant since then. Now, the respondents, they have filled up this post, and at the same time, they have said that you need not require to come to the school, and they are debarring me from signing attendance register and all. So I'm
Who are you? Srimati
Chandrama Devi is the petitioner in whose favor this honorable court already passed an order for provincialization of her service. Against that order, they have filed a review application.
Okay.
That is the review. Now, to show the plight of this petitioner, my lord, 2-3 papers from review, I'll just like to refer for your lordship's consideration. If your lordships kindly come to page 100
of the review.
My lord. Yes.
Review, which review?
Review.
94.
Yes, 94, my lord.
Only one review is there.
Only one review, my lord.
Where's the order for under for review?
Order under review is page 39.
I'm sorry, my lord, it's not page 39, it's page. Yes, my lord. Page 34, it starts. And relevant portion, your lordship will find page 37, para 5.
Yes.
As regards the entitlement of provincialization by the petitioner, we take note that although the Act of 2011 has been struck down in the meantime, but Section 4(1) of the Act provides that the services of the employees of all venture educational institutions under Section 3 of the Act shall be deemed to have been provincialized on the date of coming of force of the Act. We have also taken note that as notified, the Act of 2011 came into force with effect on 1/1/2013. A reading of the Section 4(1) of the Act of 2011 goes to show that whichever teacher was found to have been eligible as per Section 3 of the Act are deemed to have been provincialized from the date when the Act came into force, meaning thereby from 1/1/2013. The material placed before the court, particularly the pro forma for information on provincialization annexed at page 95 of the petition, clearly goes to show that the petitioner was found to be the third assistant teacher of the school concerned, and the provisions of Section 3 of the Act of 2011 as amended in 2012 provides for 3 assistant teachers arts in order of seniority to be entitled from provincialization. In other words, when the respondent authorities has arrived at their own conclusion that the petitioner is the third assistant teacher arts of the concerned school and 3 posts of assistant teacher arts are to be provincialized, it has to be understood that the operation of the law under Section 4(1) of the Act of 2011, the services of the petitioner has deemed to have been provincialized with effect from 1/1/2013. Such deemed provincialization under the operation of law cannot deprive the petitioner merely because the respondent had failed in their duties to pass any other consequential order of promotion which otherwise would not be material, as it is a provincialization of by operation of law and not by any consequential order to be passed by the authorities. From the said point of view, we declare that the services of the petitioner was deemed to have been provincialized under Section 4(1) of the Act of 2011 as per the conclusion arrived at by the respondent, and he was the third assistant teacher of the school concerned, and under Section so and so, the third teacher is entitled to be provincialized. All consequential benefits of provincialization that the petitioner may be entitled shall be provided to her within a period of 2 months from the date of receipt of the certified copy of the order. We also take note that as required under Section 10 for the government of Assam has also approved the provincialization of the petitioner. So she was initially appointed in 2006. Thereafter, my lord, she is fighting cases after cases. Last was this. So this honorable court passed an order. The post was lying vacant since 2013. Now, by this order in the IA, they have filled up the post by transferring another person, and at the same time directed me that you need not require to come to the school and debarred me from signing the attendance register and all. So, my lord, this will amount to curtailing my entire, my lord, the rights. She was trying to oust it. She was trying, like, my lord. Lordship will kindly see page 19. So I'm not saying that I have it. I have to put something. So it will amount to that since 2016, I am fighting for my provincialization. And one more thing, my lord. I'll just show the provincialization order. My lord will kindly have page 156 of the array review. Lordship's got, my lord?
Yes.
In pursuance to the government letter dated 13/8/2014, this is the order by which the posts were created, whereby so and so number of teaching and non-teaching posts have been created for Kamrup Metro District under so and so as amended. The undermentioned posts are hereby allotted to Savitri Bhorale High School District Kamrup with effect from 1/1/2013, which was recognized on 1/1/1998. My lord, serial number 2, graduate teacher Arts 3. Now down below, my lord will kindly see serial number 4, vacant. This was kept particularly vacant for me because my provincialization, although it was sent by the headmaster, it was not done at that relevant point of time. So the third assistant teacher vacant, it was me. So it was kept created for me for my provincialization because of the orders, illegal orders from time to time. It did not happen. The petitioner is filing cases. Now, after all these things, if you pass this order, post another person there, it will amount to curtailing my entire rights. So how to deal with this kind of order, in my humble submission, is absolutely uncalled for. So at this stage, my prayer is that I'm praying for stay of this order. Lordship will kindly appreciate
25/3/2025 order.
This page 19 order, 25/3/2025.
It's a March order. It has already been given effect to.
Lordship will, that is what I'm trying to convey.
That part will take care, don't worry. If you are successful, we'll place you there, send them back.
Exactly, that much only. And second is that, I may be allowed to continue in the school.
She was never provincial. The orders of this honorable court in the review petition has. Is it coming up for the first time, this IA?
No, for the first time.
Yes.
This has come up for the first time. What I would suggest to Madam, what is calling from Lordship, subject to affirm the petition, we present arrangement continues. Person who is joined is allowed to continue, subject to affirm the review petition. It happens in the review petition.
And on what ground are you challenging, are you praying for review of this order?
There are two division bench judgments which say that there could have been no provincialization of the petitioner after the Act of 2011 was
struck down.
There are two judgments on that. That is one part. Other part is her name was never forwarded by the headmaster of the school for provincialization legally in a legal manner. Since it was never forwarded and the BSc had never recommended, the SLC's recommendation at the final stage would not matter. It would bring in an illegality in the empire, which was not placed before this honorable court when the matter was heard. And therefore, the very honorable judgment who had issued the first order had again stayed it in the review. On the first motion day, the orders passed in the petition was
Stayed.
Yes.
In the review?
Yes. Lordship will find the order dated, the first order dated 25/7/2022.
Basically, the respondents, they are dezoning my entire service from 2016 to 2014. Sorry, 2006 to 2014. They are claiming that I did not serve.
There was a manipulation of reports as per us. Therefore, which could not be pointed out at that point of time.
Okay.
Therefore, if the arrangement as has been done by this order dated 25/3/2025 is allowed to continue, subject to affirm the petition, the students get their teacher to teach.
So far as manipulation is concerned, my lord. No, it can should have. Yeah. Only thing, my lord, she should not be disturbed from.
She is not a
coming to the school.
And for that, I have taken instruction whether she was actually attending school in this period. How could she attend a government school when she's not part of the
Look, she was all along continuing in her service from the venture stage itself. And one fine morning, she will be asked that you don't come to the school now onward. Because against this particular post, I was working till passing of this order in March.
Mr. H. Das. Legal counsel for the applicant. By this application, the applicant is praying for a direction suspending the order dated 25/3/2025 issued by the Inspector of Schools, KTC, M, whereby four teachers were transferred in their own grade and scale of grade and posted to the school and posted to four different schools. Stop. It is the case of the applicant that the person at serial number 4 in the order dated 25/3/2025 is occupying the place of the applicant, correct?
Yes, ma'am.
And the authorities in the said Sabitri
Bhorali High School.
High School are not permitting the petitioner applicant to report to the stop para issue notice. Majumdar, you have Mr. R. Majumdar, Standing Council, School Education
Department of School
Department appears on behalf of all the respondents.
All 5, yes, all.
All the respondents. No, 6.
6 Sabitri Bhorali High School.
Provincial school. So he can, the only paper I find missing here is the person who has already joined there, he's not a party.
That's why
I am not seeking any relief against.
you want her to go.
She came on transfer, Milo. She came on transfer. She cannot claim that this post is mine. I also cannot claim that this post is mine. Tomorrow, if the review is allowed in my favor, Milo, then she'll have to be, decision has to be taken by the government, what they'll do with her. But I am not claiming any relief against her in my, that she has been provincialized in my place.
Okay. So you are appealing for 6 also? Yes. Okay, all the opposite respondents of the opposite parties. Stop. No? When do you want? We can consider a review and dispose of the whole thing.
That is what I was saying. Around the 12th of June, my lord, we could explain.
List the matter on 12th of June. Stop.
How is the
operation of the order dated 25/3/2025 shall be subject to the outcome of review petition number 94 of 2023.
The applicant may be allowed to continue in her present place of posting.
How can we have two teachers in one post?
I am at least till review is decided till March, this passing of this order, I was
See,
signing the attendance register.
That's one thing is, I did not know that the order passing the writ petition was state.
Yes, it was state.
In the review only Majumdar has pointed out, I checked up,
Yes,
that order is now state.
I am not asking for implementation of that order. That order is state. But when all these things are pending, where is the requirement to dislodge the applicant, my lord? That is my grievance.
The dislodgement.
The moment, one second. The moment the respondents, they tell me that you don't come to the school and your lordships do not protect me, then my lord,
That's
what
why I'm
remains?
saying this, it will be the outcome of review and we'll try to dispose of the review on the next date.
No, that I'm agreeable, my lord. That I'm agreeable to. But only difficulty is that she'll have to stay back. Since 2006, my friend is saying yes.
Now, see, this is the issue. You want to continue in the school, correct?
At least, lordship.
Till the disposal of review.
Exactly, my
you want to continue.
Exactly, my
Right.
Because in
So
these
if
matters,
this court allows you to continue,
yes,
that person at serial number 4 will have to go back. Will have to go back. There's no vacancy in the other in your school apart from that vacancy which you're claiming. Correct. That person, that Aparna Nyoko, whoever it is, will have to go.
the
And
entire,
knowingly you did not make her a party.
Milord, if I may just explain, Milord, I am not, this entire mess has been created by the respondent. Since 2013, the post was lying vacant. You did not fill up. You did not feel for the students since 2013.
That's part.
Yes, that's why.
What we have considered.
So now, in 2025, you filled up, fine, very well. Now you have to take care of me also. You are a state. A person who has worked from 2006 to 2025, March, one fine morning you will oust her that another person has come against your post and you go.
The operation of the order date is so and so. In respect of, that what school of it?
Savitri Borade High Secondary School.
Subject to the outcome of review petition. I can't help you more than that. You have not met your party.
No, I am not seeking any relief. She may not, what I'm trying to, I understand.
Just tell me, how
Yes.
many vacancies are there?
One vacant post.
Yonder,
Yes,
Yonder, isn't it?
yes, I'm there.
Now they've brought her here to your
They have
vacant
brought her here. What I'm trying to,
because you have not been provincialized.
because in this type
The
of,
other one is provincialized.
no, she was already she was provincialized in another school, Milord. Milord, in this type of matters, Milord, continuation of service, Milord, has significance. That's why.
That's why if everything goes in your favor,
Lordship.
then that time will see that your continuation is there without any disruption. That part is there. But if something goes wrong in the review,
Yes.
then everything goes.
Otherwise, also, if I lose the review, Milord, then everything goes me. My provincialization goes me.
Oh. But if you are successful in the review, if the review petitioners are not successful,
yes,
then even if there's some disruption in your service period, that also this court has the power to
fine.
rectify that.
Lordship takes care of that, Milord. That is enough.
That's
for me.
what I'm saying.
Much of life.
That we're keeping it in mind.
Much of life. Milord, can it be on 17th, Milord? 17th of June, Milord.
Yes, Majumdar.
Much of.